I have not
It is
filed the
hearing
filed the
matter.
affidavit. Hearing matter, but affidavit reply has not been filed. That's why I want only 1 week or 10 days time, my lord, so that
Okay.
it come in the file. Let it come on 15th of
MS and cycle and council
15th of May.
is allowed 1 week time
1 week time.
to file reply to the affidavit filed by the
Government.
respondent,
Council.
by the respondents. Huh? List after 1 week.
Yes, my lord, let it be on 15th.
Huh?
Then I get 15th of May. I can prepare it, my lord. Then
Okay.
fix that.
15 May.
Oblige.
May it please, Your Lordship.
Uh,
May I pay for listing of the interrogative application on Monday?
Any urgency involved?
My lord, only for withdrawal of certain names, petitioners' names from the writ petition.
Okay.
Apply.
I beg to mention for listing, admission matter lordship on 8 or 9, 8 if possible lordship.
Okay. 8.
Like
May I please, Your Lordship? Lordship, item number 8, Your Lordship. Lordship, we'd like to file our affidavit, Your Lordship.
How is it coming in the hearing when
Your Lordship,
pleadings are not complete?
Lordship. Lordship, I pray for this.
Okay, heard J. Abidin and the counsel for the petitioner. MS
D. Musahari, Your Lordship.
D.
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 Musahari.
Musharil and the standing counsel.
Secondary education, Your Lordship.
Secondary education is allowed how much time?
Lordship, 2 weeks, Your Lordship.
2 weeks time to file contract. List after 2 weeks.
My lord,
Lordship, date.
I need a date, my lord.
You need a date. Why?
My lord, it's a pension matter. A widow is before my lord, my lord.
2 weeks today, 1 week.
Let it be 22nd. It will be 3 weeks exactly.
Lordship.
22nd.
Yes, sir.
Lordship. Oblige, Your Lord.
May I please, Your Lordship? May I pay for listing of a miscellaneous application for restoration, Lordship, next week?
Restoration.
Restoration.
Okay. 7th.
May I please, Your Lordship, item number 7. We have the consent from the other side, Your Lordship. The matter may be fixed after 2 weeks.
You are 40.
Respondent number 9.
Have you taken the consent?
Yes, your
Petitioner's consent?
Yes, Your Lordship.
Okay. On request made by Mr.
A. Rahman.
Huh?
A. Rahman.
A. Raman, then counsel for the respondent number 9. List the matter after
2 weeks. Only phone করেছে। Only phone করেছে।
You are for petitioner?
Yes, ma'am. I think consent was not given, just informed, but consent was not given. Let the matter be reached, ma'am.
Your Lordship, my senior told him yesterday, Your Lordship.
Then next week only that matter short date because family pension granted to second wife.
Okay. Okay. 13th.
Yes.
May I please, Your Lordship? We are for listing, Lordship. Matter regarding Lordship, pension matter, Lordship. Next date, Lordship, next date, Lordship. Next week, Lordship, any date.
Next week, many cases are now listed. 14th.
Another Lordship, withdrawal, Lordship.
Oh.
1-5, Lordship.
Okay.
May I please, Your Lordship? I'd like to mention item number 10. It may be passed over for the day.
You are for?
Petitioner, Your Lordship.
Your good name?
JP Bora on behalf of B. Pukasta.
On request made on behalf of Mr. B. Castle and the counsel for the petitioner. List after 1 week or 2 weeks?
2 weeks.
2 weeks.
Declare blood.
May I please, Your Lordship? My lord, I beg to mention for listing of 2 writ petitions, Lordship, on 14th of May, Lord. Obliging. May I please, Your Lordship? I beg to mention for listing 1 writ petition, Lordship. 8 or 9, Lordship.
14th.
Much of.
Item 1 for motion.
Well, in this case, I have received the instruction. Regarding his provincial election, his name has not been recommended by the district level scrutiny committee. May I place the same one?
Let them file an affidavit and then your lordship will dispose it of.
Yes,
On what grounds?
That is not reflected from the,
You file an affidavit.
my lord.
Heard Mr.
H dash.
H. Das, learned counsel for the petitioner. Mr.
PK Bora.
P.K. Bora, learned standing counsel,
Elementary education.
elementary education, submits that he has received instruction
My lord.
and prays for 1 week or 2 weeks.
My lord, on 2 weeks, my lord, on.
Prays for 2 weeks time to file affidavit.
Yeah.
Should we issue notice? Notice has gone or not?
No, my lord. My lord, since he is filing an affidavit, let it come up on 15th, your lordship will dispose it of.
No, you will be appearing on behalf of all the respondents, isn't
No,
it?
my lord. I am appearing on behalf of 1, 2, 3,
4. 4 also.
5, DC government.
How
Four.
about 4? 4.
4, 5 is government.
DSC too. DSC, district. District scrutiny committee.
So let notice goes in, all the notice are complete and then we'll fix it for.
My lord.
Okay, heard Mr.
H dash.
H. Das, learned counsel for the petitioner, issue notice. Mr. P.K. Bora, learned standing counsel, elementary education, appears on behalf of 1, 2, 3, and 4. He also submits that he has received instructions and prays for 2 weeks time to file affidavit. Okay. Praise a lot. District scrutiny. B. Deori. Mr. B. Deori, learned governor advocate, appears for the respondent. MS D.D. Burman, and additional senior governor. Appears for respondent. List after 2 weeks. 2 weeks.
My lord, obligement.
My lord, can it be on 15th of May, my lord? It will be 2 weeks, my lord.
15th.
Item 2. My lord, the matter may pass over the timing, my lord. Senior counsel in conflict number 10, my lord. My lord, record has come, my lord, as per lordship direction, my lord.
Yeah, your lordship wanted to have a look at the missing IA that was filed in
3297, my lord, in WBC
disposed
number
of
5.
writ petition.
So, my lord, time being, my lord, senior counsel.
My lord, can it be then in that case, lordship may take up this matter at 2. In the meantime, I'll also have some other matters at 2.
It's up to you, or we can fix a different date.
My lord, there is some urgency on our side.
Then
So
why are you asking for 2?
at 2 p.m. my lord. Because today I am not seeking any adjournment.
Okay.
At 2 only.
Item 3.
May I please, your lordship? Lordship, in this matter, the respondent authority has filed an affidavit.
Hmm.
So regarding this, I need to bring some instructions from the petitioner.
Okay. On request made by MS.
A. Sharma on behalf of Mrs. A. Bujurgurwa.
Sharma, learned counsel, appearing on behalf of A. Bajur Barwa, learned counsel for the petitioner. List the matter after.
On, my affidavit file on a second.
Secondly, your lordship, we need to file our affidavit as elementary has filed their affidavit. Here, your lordship, we need to file our affidavit. Instruction has received, your lordship.
Okay, then heard so and so for the petitioner. MSP Das, learned standing counsel,
Secondary.
education department, submits that she has received instructions. Secretary is a party.
Later on, they had immediately.
First title. Appearing for the respond number 8. Correct.
Yes, sir.
Submits that she has received instructions and praise for
2 weeks time.
2 weeks. To file contract. Praise not. List after 2 weeks.
Much obliged. Deeply obliged.
Item 4 and 5.
My please, your lordship. Lordship, the conducting counsel, Mr. K. Kolita is on legs in another court. Kindly pass over for time. Kindly pass over for some time.
Yes, Fukan. After some time.
Deeply.
Item 12 for hearing, Potter matter.
Lord, we have completed our, Mr. Roy has completed his part, Mr. S. Chakravarti is to address the Lord.
Who's is Chakravarti?
Now, just now he has taken,
Oh.
fixed the matter at 2 PM, my Lord.
Where is he gone?
This is the matter, my lord, of the challenge the order of the labor court. The lordship heard the matter last week. The labor court may not without lordship, I addressed your lordship. Should we file a small notes of convenience, my lord? You know, that's better, my lord.
My lord, here I am representing the respondent number 2 as an amicus, my lord. My lord, the whole question which has come for consideration before a lordship is whether the management, that is the respondent number 2, will have the right to adduce evidence before the labor court. Here it is a case where for some reason the writ petitioner was terminated from service. An industrial dispute was raised and the matter has gone to the labor court for determination of the dispute. My lord, the writ petitioner's argument is that since the management has not decided that they would like to adduce evidence, then the opportunity cannot be granted. And in that respect, they have relied on 2 decisions of the Supreme Court. Lordship, for the time being, Lordship met the list of books to their answer. My lord, here this case is squarely covered by Supreme Court's decision, where the Supreme Court has held that if the employer terminates a person or a workman without holding an inquiry, then it is the employer will have the right to adduce evidence before the tribunal or the labor court to justify their action. This law was laid down way back in 1965 by the Supreme Court. My lord, I have given the list of books for the time being since it has not come. I'm reading AIR 1965 Supreme Court 1803.
What in Namtaki?
That's not me.
Motipur Sugar Factory versus workmen of the Motipur Sugar Factory Private Limited versus
Give the
Motipur.
citation.
AIR 1965 Supreme Court 1803. Now, my lord, this judgment has been referred time and again in all the cases. Lordship may have, since it is not, I'm reading paragraph 12. Now, paragraph 12. If it is held that in cases where the employer dismisses his employee without holding an inquiry, the dismissal must be set aside by the tribunal only on that count. That is exactly what the workman is submitting before a lordship. That inquiry without inquiry, the workman was dismissed, and that amounts to unfair labor practice. So the tribunal has no option but to hold the termination is bad. And the employer will not have the right to justify the action taken by adducing evidence on the question of the misconduct. It would inevitably mean that the employer will immediately proceed, but after, if it is dismissed, then employer will again proceed with the inquiry and then take an action. Inquiry and pass an order dismissing the employee once again. In that case, another industrial dispute would arise and the employer would be entitled to rely upon the inquiry which he had held in the meantime. This course would mean delay, and on the second occasion, it will entitle the employer to claim the benefit of the domestic inquiry. On the other hand, if in such cases the employer is given an opportunity to justify the impugned dismissal on the merit, the employee has the advantage of having the merits of his case being considered by the tribunal for itself, and that clearly would be to the benefit of the employee. That is why this court has consistently held that. Now, this is very important. If the inquiry, domestic inquiry, is irregular, invalid, or improper, the tribunal may give an opportunity to the employer to prove this case, and in doing so, the tribunal tries the merit itself. This view is consistent with the approach which industrial adjudication generally adopts, with a view to do justice between the parties, without relying too much on technical considerations, and with the object of avoiding delay in the disposal of industrial disputes. Therefore, we are satisfied that no distinction can be made between cases where the inquiry has in fact been held. We must therefore reject the contention that as there was no inquiry in this case, it was not open to the respondent to justify the discharge before the tribunal. So, my lord, the Supreme Court has categorically held that if a workman is dismissed without any inquiry, then for that reason, that no inquiry is held, the termination or the dismissal order cannot be held to do that. In that scenario, the employer should be given an opportunity to establish the allegation before the tribunal. So in that situation, the tribunal becomes the inquiry officer and find out whether there were materials to justify the action of dismissal. Now, this case, Motipur Sugar, was again considered in 1972, 1 SSC 595. Delhi Cloth and General Mills versus Ludwig Singh. 1972, volume 1 SSC 595. In that Motipur, I'm just reading out another paragraph in that 1965 judgment, paragraph 11. It is now well settled by a number of decisions of this court that where an employer has failed to make an inquiry before dismissing or discharging a workman, it is open to him to justify the action before the tribunal by leading all relevant evidence before it. In such a case, the employer would not have the benefit which he had in cases where domestic inquiries have been held. The entire matter would be open before the tribunal, which will have jurisdiction not only to go into the limited question open to the tribunal where domestic inquiry has been properly held, but also to satisfy itself on the facts adduced before it by the employer, whether the dismissal or discharge was justified. So, my lord, paragraph 11 and 12 is very categorical. It says that if no inquiry is held prior to dismissing or terminating an employee, the employer will have the right or opportunity to adduce and satisfy evidence to satisfy the tribunal to examine the charge. Now, this Motipur factory case was again considered in 1972 1 SSC. I am referring paragraph 61. And all the cases were taken into account what the Honorable Supreme Court in paragraph 61 has summed up. From the above decisions, the following principles broadly emerge. Number one, if no domestic inquiry had been held by the management, or if domestic inquiry, or if the management makes it clear that it does not rely upon any domestic inquiry, that may have been held by it. It is entitled to straightaway adduce evidence before the tribunal justifying this action. The tribunal is bound to consider that evidence so adduced before it on merits and give a decision thereon. In such a case, it is not necessary for the tribunal to consider the validity of domestic inquiry as the employer himself does not rely on. Now, my lord, the situation is if no inquiry is held or the management at the very inception concedes that no, whatever the inquiry was held, we are not relying on it, it is a defective inquiry. So in that scenario, the management will have the right to adduce evidence in support of the charge. Meaning thereby what the management would have done by conducting an inquiry, that exercise will now be undertaken by the labor court. For that, my lord, no pleading as such is required that we would like to evidence adduce evidence on merit. It is the right of the employer if no inquiry is held. Then, my lord, again, after 72, then 1973, another case, 1 SCC 813. This is also a very leading case in the industrial dispute matter. The workmen of Firestone Tire and Rubber Company. Now, my lord, I'll relying on paragraph 32. In Ludbut Singh case, as well as in Firestone's case, Motipur Sugar Factory has been relied. Now, in paragraph 32, it is once again clear. From those decisions, the following principles broadly emerge. 1. The right to take disciplinary action and to decide upon the quantum of punishment are mainly managerial function. But if a dispute is referred to a tribunal, the latter has the power to see if action of the employer is justified. Now, here, 32 subpara 4, the Supreme Court is very categorical. Even if no inquiry has been held by an employer, or if the inquiry held by him is found to be defective, the tribunal, in order to satisfy itself about the legality and validity of the order, had to give an opportunity to the employer and the employee to adduce evidence before it. It is open to the employer to adduce evidence for the first time justifying this action, and it is not open to the employee to, and it is open to the employee to adduce evidence contrary. So, my lord, the contention of the writ petitioner workmen that the management does not have the right or direct or does not have the right to straightaway adduce evidence to justify his dismissal if no inquiry is held is against the settled position of law. Now, in this case, the 11A was considered. So, my workman's contention that under 11A, the court will have to decide the quantum of punishment on the basis of the materials on record. If your lordship takes up 11A of the Industrial Disputes Act, now, my lord, 11A was subsequently introduced in the Act. Earlier, what was the position? Earlier, whenever an order of termination was passed and the matter goes to the tribunal had limited jurisdiction. The tribunal had the jurisdiction to see whether the inquiry was properly held or not. Now, if the tribunal holds earlier that if the inquiry is proper, then the tribunal did not have the jurisdiction to decide on the quantum or on the quantum of punishment. So, whatever punishment the management imposes, that would have attained finality. Now, in view of 11A, power has been given to the tribunal, where the tribunal or the labor court will not only have the jurisdiction to see whether the inquiry was properly held or not, or whether the management could justify their action of terminating by adducing evidence before the tribunal will have the additional jurisdiction to examine the proportionality of punishment. If the charges are held to be established, whether on those established charges the punishment of dismissal or termination is justified or not. In that scenario, the tribunal will have the jurisdiction or power to reduce the punishment. And in 11A, the proviso, it has been given that provided that in any proceeding under this section, the labor court, tribunal or national tribunal, as the case may be, shall rely only on the materials on record and shall not take any fresh evidence in relation to the matter. Now, this is what my senior has interpreted, that the tribunal will not have the power to accept fresh evidence. Now, this aspect has been dealt with in that Firestone case. Hey, it doesn't to isn't download download Now I'm reading, my lord. Paragraph 48-49.
Of
That 1973 1 SSC Firestone's case. 48-49. We are not inclined to accept the above contention of Mr. Deshmukh. The proviso specifies matters which the tribunal shall take into account and also matters which it shall not. The expression materials on record occurring in the proviso, in our opinion, cannot be confined only to the materials which were available at the domestic inquiry. On the other hand, the materials on record in the proviso must be held to refer to materials on record before the tribunal. They take in the number one, the evidence when the taken by the management at the inquiry and the proceedings of the inquiry, and number two, the above evidence that in addition any further evidence has been laid before the tribunal, and number three, evidence placed before the tribunal for the first time in support of the action taken by the employer as well as the evidence adduced by the workman. So, my lord, the expression materials on record will not only mean the materials of inquiry, it will mean the materials placed during inquiry plus the materials if again placed before the tribunal straight away where no inquiry is held. So the tribunal will have the power to examine the evidence adduced by the employer for the first time before the tribunal, and on that evidence, if the tribunal holds that the charge is established, then also the tribunal can further go into the question as to whether the action of awarding dismissal or termination is proportionate to the charge. Now, in this case, my lord, admittedly, no inquiry was held before termination. So, the issue whether the termination is good or bad is subject to decision before the labor court. Here, your lordship definitely would not like to examine that aspect because no decision has been taken by the labor court yet. The only question which calls for an answer before your lordship is whether the management or the respondent number 2 will have the right to adduce evidence before the labor court. In view of these decisions, it is well established that where no inquiry is held, the employer will have the right to adduce evidence before the labor court. And the labor court is bound to consider that evidence and give a finding. Now, the judgments which were referred by my senior, that is the Karnataka Roadways, reported in 2001 5 SCC 433, upholding the decision of Shambhunath Goel case.
1 minute. Where has the judgments gone? It's 2001, isn't it?
2001 5 SCC 433, that is the judgment. Now, my lord.
1 minute, 1 minute. Is it here?
I can hand up another copy.
No, I yes.
But, my lord, there can be two scenarios where the employer dismisses a workman. Number one, allegation leveled, but no inquiry is held. And number two, allegations leveled, inquiry held, and action taken. Now, if in scenario one, where no inquiry is held, then management will have the right to adduce evidence before the labor court in support of the allegation. Now, in scenario two, where there is evidence in an inquiry, then the management will have two options. Management will rely on the inquiry. My lord, management will rely on the inquiry before the labor court, And if the inquiry is held to be bad, then the management will have the additional chance of adducing further evidence in support of the charge. Now, in Shambhunath Goel's case, which has been upheld in Karnataka State Road Transport case, the question which was decided, if the management holds an inquiry and the inquiry is held to be bad, then the right of the management to adduce additional evidence or further evidence will be given only when the management takes up that plea in the written statement. At the first instance, then yes, we are relying on the inquiry, and if the inquiry is held to be bad, then we must be given an option or opportunity to adduce additional evidence. Now, if that is not taken, then, my lord, the management will not have the right. That is what Shambhunath Goel's case, ratio of Shambhunath Goel's case is, and which has been upheld by the Supreme Court in Karnataka Road Transport. So, this Shambhunath Goel's case and Karnataka Road Transport case has no application at all, because here no inquiry has been held. Now, my lord, if I take your lordships to the 2001 5 SCC, what was the ratio of Shambhunath Goel's case? Your lordship will find at paragraph 15. This is ultimately, this Shambhunath Goel's case was referred to a larger bench, where the larger bench has held that the law laid down in Shambhunath Goel is the correct law. Paragraph 15. The question again rose in the case of Shambhunath Goel as to the propriety of waiting till the preliminary issue was decided to give an opportunity to the management to adduce evidence, because after the decision in the preliminary issue on the validity of the domestic inquiry, either way there was nothing much to be decided thereafter. Therefore, in Shambhunath's case, this court once again considered the said question in a different perspective. In his judgment, the court, after discussing the earlier cases, including Shankar Chakravarti and so, which was a judgment of this court, laid down the following principles. Now, this paragraph 16 of Shambhunath is quoted. We think that the application of the management to seek permission of the Labour Court or Industrial Tribunal for availing the right to adduce further evidence to substantiate the charge or charges framed against the workman referred to in the above passage is the application which may be filed by the management during the pendency of its application before the Labour Court or Industrial Tribunal seeking its permission under Section 33 of the Industrial Dispute Act to take a certain action or grant approval of the action taken by it. The management is made aware of the workman contention regarding the defect in the inquiry by the written statement of defense filed by him in the application filed by the management under 33 of the Act. But, my lord, then mark, when the question arises in a reference, that is under Section 10. So, this is a case under reference under Section 10. When a question arises in a reference under Section 10 of the Act, after the workman has been punished pursuant to a finding of guilt recorded against him in the domestic inquiry, there is no question of the management filing any application for permission to lead further evidence in support of the charges or charges framed against the workman for the defect in the inquiry is pointed out by the workman in the written statement of claim filed in the Labour Court or the Industrial Tribunal after the reference had been received by the management. Reference has been received and the management has the opportunity to look into the statement before it files its written statement of defense in the inquiry before the Labour Court or Industrial Tribunal and could make the request for the opportunity in the written statement itself. If it does not choose to do so at that stage, it cannot be allowed to do it at any later stage of the proceeding by filing any application for the purpose, which may result in delay, which may lead to wrecking the morale of the workman and compel him to surrender, which he may not otherwise do. So, my lord, what is the ratio of Shambhunath Goel's case is, if the management holds an inquiry and the management in their written statement relies on the legality or otherwise of the inquiry, then management, if the management does not plead or takes leave of the tribunal to adduce evidence, additional evidence, if the inquiry goes bad, then after the inquiry is held to be bad, the management will not have the right to adduce further evidence. That is the law. So, my lord, to apply this law in the present case, my lord, firstly, there has to be an inquiry. So if there is no inquiry, so this law does not apply. So if there is no inquiry, there is no question of examining the validity of the inquiry. Now, in this particular case, my lord, if your lordship takes up their writ petition, lordship will find at page 21 what was prayed before the labor court by the workman. This is the application annexure I at page 21. Charges leveled, dismissal order issued, matter goes to the labor court, where both parties have filed their written statement. Now, at that stage, the workman, the writ petitioner workman has filed this application. Now, if your lordship comes to the page 23, what was the specific prayer made in the application? In view of above, the Honorable Court may frame the following preliminary issue and dispose of the case based on the decisions of the preliminary issue. Now, the workman has prayed before the labor court to frame a preliminary issue that whether the management before termination of the service of the applicant workman so and so has held a domestic inquiry by adopting a fair procedure with due regard to the principles of natural justice. And if not, whether the application filed by the workman is liable to be allowed for adopting unfair labor practice for not holding domestic inquiry. Now, by this preliminary issue, first, the workman wanted the labor court to decide whether there was a fair inquiry. My lord, when there is no inquiry at all, where is the question of a decision as to whether there was a fair inquiry? Now, the second part of the application refers to a prayer which says that if the inquiry is not fair, then the order of dismissal should be straightaway held to be bad because it amounts to unfair labor practice. Now, as I have already referred to, my lord, in Motipur Sugar Factory, followed by Ludbut Singh and the Firestone case, the Honorable Supreme Court has held that if there is no inquiry, the workman, in the dispute raised by the workman, the employer, that is the management, will have the right to adduce evidence straight away to the labor court for the first time. In that case scenario, the labor court will decide the question of the question raised in the reference on the basis of evidence adduced by the management and see whether the punishment of dismissal or termination is good or bad. And if it finds that the termination is disproportionate, then under 11A, the labor court can modify the penalty. So, this application seeking to frame a preliminary issue and to decide if the inquiry is held to be bad, to interfere with the punishment, my lord, is totally against the law laid down by the Supreme Court. Here, what the labor court has done, labor court has decided this application by saying that we are not going to frame any preliminary issue. Since you have adduced evidence, the management will have the option to adduce evidence. Now, another question which requires a consideration, if your lordship takes up their additional affidavit, writ petitioner, in this writ petition, in that additional affidavit,
1 minute.
at page 45,
Affidavit in opposition.
additional affidavit, which is numbered 13798/96, filed on 17th of August 2018.
Yes.
Now, this is the written statement of the management. Now, if your lordship comes to page 53, the prayer made in the labor court by the management in the written statement is management had raised one question of maintainability of the reference, and accordingly at page 53, I'm reading the prayer. It is therefore prayed that your honor would be pleased.
1 minute. Don't have a page 53 here.
Yeah, my lord.
Is it what running
The
page?
running 149.
My lord, the one which has been given to me from this honorable court is,
149 is the running, my lord.
that has not been given. Has your lordship got it? It is therefore prayed that your honor would be pleased to frame preliminary issue about the maintainability of the application, as the applicant has not implemented the government of Assam. So this is a preliminary issue, and in at page 54. And if, the third line, my lord, and if the preliminary issues decided against the management may be allowed to prove their case on merit. So, my lord, even then, my lord, when it is not required to take that leave, the management has already taken the leave from the labor court.
Maintainability, which is it.
There are two parts in the written statement prayer. One is maintainability of the reference as a preliminary issue, and if the preliminary issue regarding maintainability is decided against the management, then the management should be given the liberty to prove their case on merit. That means, though it is not required as such in terms of the judgment of the Supreme Court, it is his right. But here, my lord, management, as what I see as abundant caution, has taken that leap, has made a specific prayer in the written statement that yes, we have to prove, we may be given the opportunity to prove the charges before the labor court by adducing evidence. So, my lord, the question raised by the writ petitioner that the management employer will not have the right to adduce evidence is legally unsustainable in view of the decisions which I have already referred to. The prayer made in the application, which has been rejected, and which
This is your written statement?
my lord, it starts from page 45. In the additional affidavit is the written statement of the management, my lord, before the labor court. It starts from page 45.
That's the problem, no? Your page is
My lord, I'm an amicus, and all
Oh,
these
my lord,
details have been given by this honorable court, my lord.
the-
I am not
The
originally
statement-
representing the management.
Written statement at running page 141.
141. Okay.
Now, it is the written statement. And at page 54, running page 54, running page 150. The written statement of the management starts from running page 141, and it ends at page 54, which is 150. Here, there is a specific prayer made by the management to permit them to prove the charges on merit, though it is not required in view of the judgment.
Prove their case on merit.
Prove their case on merit. That means, prove what is the case of the management. Management case on merit means, if I have issued an order of dismissal, if I did not hold any inquiry, then I have the right to prove the case on merit, means I have right to adduce evidence on the charges. That is what the Supreme Court says in Motipur Sugar Factory. No inquiry and defective inquiry stands on the same footing. And the management, if the management does not hold any inquiry before terminating, then, my lord, the management will have the right to adduce evidence. The submission advanced and the judgment relied upon by the petitioner that the management has not pleaded in the written statement, it is in respect of adducing further or additional evidence where there is an inquiry. So, if there is no inquiry, this decision of Shambhunath Goel and Karnataka Road Transport has no application, my lord. We have to apply the ratio of decided cases on the facts of the cases. Shambhunath Goel case upheld by the Supreme Court in Karnataka Road Transport on a different footing, where there is an inquiry and the management relies on that inquiry and the management fails to establish the fairness of the inquiry. In that scenario, if the management does not plead for additional evidence in the written statement, that opportunity of leading additional evidence by the labor court will not be permitted by or the labor court will not permit the management to adduce that additional evidence. So that question will come only when there is an inquiry preceding the order of dismissal. Here it is a case, no inquiry, admitted position, my lord. It is nobody's case. The workman has said no inquiry was done prior to dismissal. The management in the written statement nowhere has stated that there was an inquiry. So the question or a prayer to frame a preliminary issue to decide the fairness of the inquiry is totally unfounded, my lord. What they have basically pleaded before the labor court is, since there was no inquiry, so the termination order should be held to be bad because it is violation of the schedule of the Industrial Disputes Act, which speaks of unfair labor practice. But the Supreme Court has held that merely because no inquiry is held, and for that reason, if the termination is interfered with, then it will give the management another opportunity to conduct an inquiry subsequently and take the same decision. Then again, an industrial dispute will be raised, and again, the same thing will follow. So, to cut short of the litigation period, the Honorable Supreme Court has held that the management will have the right. In that case, if the management still does not adduce any evidence to substantiate the charges, then the question will be different and the law will take its own course. Here it is a case where the management has prayed before the labor court in the written statement that they may be given the opportunity to prove the case on merit. Accordingly, they have submitted or filed evidence in affidavit, that is the examination in chief of 13 witnesses. And they were supposed to cross-examine. Workman has adduced evidence. Now, Supreme Court in Motipur has also held that if the employer adduces evidence before the labor court for the first time, opportunity of adducing contra evidence should also be given to the workman. So, in my respectful submission, my lord, this is the case where the order of the labor court is not bad. The argument advanced that the management cannot lead evidence without taking that plea in the written statement is not legally correct. That question will come only when there is an inquiry, as has been held in Shambhunath Goel's case, which has been subsequently referred and upheld by the constitutional bench, saying that the law laid down in Shambhunath Goel's case is the correct law. Where there is no inquiry, Motipur Tea Estate, 1965, followed by Ludbhu Singh's case in 1972, and then again in Firestone's case in 1973, all along the Honorable Apex Court is maintaining in one stand that the employer will have the right to adduce evidence. Yes, sir. So, my lord, I am not submitting anything on the merit of the allegation because it is for the labor court.
Have we got the list of books?
Okay.
On 1965,
My lord, 1965, your lordship may come to paragraph 10, 11 and 12, which I'll be referring.
okay,
I'm reading, if your lordship.
no, that's okay. I'll read it later.
My lord. Paragraph 10, what was the question? And paragraph 11, the Supreme Court.
Karnataka State is not
My lord.
yours. Then the other one is
My lord.
Firestone.
My lord, then the second case I'm referring is 1972, 1 SCC 595, Ludbhu Singh's case. Paragraph 61.
Then Firestone.
And in paragraph 61, my lord, the present case will be covered by 61 Roman 1, the first one. If no inquiry has been held by the manager, starts with 61(1). Then in Firestone's case, my lord, I'll be referring, my lord, paragraph 32.
Yes.
Then paragraph 37. If there has been no inquiry held by the employer, or if the inquiry is held to be defective, it is open to the employer even now to adduce evidence for the first time before the tribunal justifying the order of discharge or dismissal. Paragraph 37. We are not inclined to accept the contention on behalf of the workman that the right of the employer to adduce evidence before the tribunal for the first time recognized by this court in its various decisions has been taken away. Then, my lord, paragraph 40, 41A. Firestone's case, paragraph 40, 41A, 48 and 49. Now, here the Honorable Apex Court has examined the power of the labor court or the tribunal under 11A.
1 minute.
Now, if the Lordship reads 48 and 49, which is at page 833. Apex Court has examined the provision of the statute and interpreted the proviso in 11A, what the material on record. That is, the proviso says, as the case may shall rely on the materials on record and shall not take any fresh evidence in relation to the matter. So, what would constitute the material on record has been interpreted in 48 and 49. The proviso specifies matters which the tribunal shall take into account and also matters which it shall not. The expression materials on record occurring in the proviso, in our opinion, cannot be confined only to the materials which are available at the domestic inquiry. On the other hand, the materials on record in the proviso must be held to refer to materials on record before the tribunal. They take in, number one, the evidence taken by the management at the inquiry and the proceedings of the inquiry. That is one material. The above evidence and in addition, any further evidence laid before the tribunal. That is, if the inquiry is held to be bad, then the further evidence which the management adduces will also constitute materials on record. And number three is the situation where no inquiry is held. Evidence placed before the tribunal for the first time in support of the action taken by an employer, as well as the evidence adduced by the workman contract. So, my lord, if the employer adduces evidence in the labor court for the first time to justify the action, and the evidence adduced by the workman in defense will constitute the materials on record. On that materials, the labor court or the tribunal will decide under 11A the quantum of punishment, whether it is proportionate or disproportionate. Now, if on the basis of the evidence adduced by the management for the first time, it appears that the charges are established, then under 11A, labor code will further go into that question whether the ultimate penalty of dismissal or discharge, termination is proportionate to the charges. And in taking that decision on the quantum of penalty, the labor court will consider the evidence placed before it. The materials on record would mean the evidence adduced by the management and the workman for the first time in the labor court in support of the allegation.
Yes.
So, in view of these judgments, the order under challenge requires no interference because the law is well settled. And the argument advanced or the contention raised that the management did not file any application to lead additional evidence in terms of Shambhunath Goel's case and Karnataka Road Transport is legally not sustainable because first of all, there was no inquiry held, and so there is no question of adducing additional evidence.
Okay.
No, my lord, my learned friend has relied on cited decisions of the Supreme Court in Motipur, Delhi Cloth, and other cases. These are in 1973-72. All these Motipur cases and Delhi Cloth Mills cases were relied on by the judgment that I've given to Karnataka High Court. My lord, Karnataka case was because of the conflicting decisions, the larger bench of 5 judges, my lord, was constituted to decide this issue. Now, my lord, my learned friend has referred to the case of Motipur. Motipur, he is quoted. The judgment, my learned friend, the part has been quoted here. Now, my lord will kindly take up that judgment for a while, just for a while. 2001 5 SCC. I'll read only 2 paragraphs, my lord. In page 439, this Motipur Sugar Factory, 439, Lordship got it. This Motipur has been referred to. My learned friend has read this part. And in paragraph 11, Delhi Cloth Mills has been referred. Now, my lord will kindly come to paragraph 12. I'll just read paragraph 12 and 13, my lord, for your lordship. That before the proceeding is closed, before the proceedings could rise, there rise some doubt as to whether it is open to the management to seek right of leading fresh evidence at any stage, including at a stage where the tribunal labor court had concluded the proceedings and reserves its judgment on the main issue. Now, my lord, para 13. The above judgment of the DCM case has again been considered in Cooper Engineering. Para 22. We are therefore clearly of the opinion that when a case of dismissal or discharge of an employee is referred for industrial adjudication, the labor court should first decide as a preliminary issue whether the domestic inquiry has violated the principles of natural justice. When there is no domestic inquiry or defective inquiry is admitted by the employer, my lord, kindly note that if there is admitted by the employer, there will be no difficulty. But when the matter is in controversy between the parties, the question must be decided as a preliminary issue. On that decision being pronounced, it will be for the management to decide whether it will adduce the evidence. It will not be thereafter permissible in any proceeding to raise the issue. We should also make it clear that there will be no justification for any party to stall the final adjudication of the dispute by the labor court by questioning the decision with regard to the preliminary issue, when the matter, if worthy, can be adjudicated even after the final award. It will also be legitimate for the High Court to refuse to intervene at this stage. We are making these observations in our anxiety that undue delays and so. Next, as has been seen from the above, the Cooper Engineering has held when the industrial tribunal was called upon to decide the validity of the domestic inquiry, and the same had been tried by the preliminary issue, and thereafter it was necessary, the management was to give an opinion. Now, my lord, para 15. The question again arose in the case of Shambhunath Goel as to propriety of waiting till the preliminary issue was decided to give an opportunity to the management to adduce evidence, because after the decision in the preliminary issue, the validity of the domestic inquiry either way, there was nothing much left to be decided. Therefore, Shambhunath Goel case, this court once again considered the said question in a different perspective. In this judgment, the court, after discussing the earlier cases, including the Shankar Chakrabarti Britannia factory, which was judgment of this court subsequent to the Cooper Engineering case, laid down the following. We think that application of the management to seek permission of the labor court or industrial tribunal for availing the right to adduce further evidence to substantiate the charge or charges framed against the workman referred to in the above passage is the application which may be filed by the management during the pendency of the application made before the labor court or industrial tribunal seeking permission under section 33 Industrial Dispute Act to take certain actions or to grant approval of the same action taken by it. The management is made aware of the workman's contention regarding the defect in the domestic inquiry by the written statement of defense filed by him in the application filed by the management under section 33 of that act. Then, if the management chooses to exercise its right, it must make up its mind at the earliest stage and file the application for that purpose without any unreasonable delay. But when the question arises in a reference under section 10 of the act, after the workman had been punished pursuant to a finding of guilt recorded against him in the domestic inquiry, there is no question of the management filing any application for permission to lead further evidence in support of the charge or charges framed against the workman. For the defect on the domestic inquiry is pointed out by the workman in his written claim statement filed by the before the labor court, industrial tribunal, after the reference has been received by the management, and the management has the opportunity to look into the statement before it files its written statement and defends in the inquiry before the labor court in the industrial tribunal, and could make the request for opportunity in the written statement itself. If it does not choose to do so, at that stage, it cannot be allowed to do so at any later stage of the proceeding by filing an application for the purpose which it may result in delay, which would lead to wrecking the morale of the workman and compel him to surrender so and so. Now, my lord, this is what the Supreme Court has held, that I file my written statement, I take a specific plea that there was no inquiry. You know that there is no, then if after knowing it, you must in your written statement take the plea that yes, either you say that there was an inquiry, there was no inquiry. If there is no inquiry, then the labor court or tribunal may grant the opportunity. Now, my lord, kindly see what statement they have made in the written statement. My lord will take up the additional affidavit that I have filed before Lordship at running page 190.
Yes.
119, my lord, para 22. This is the written statement, relevant part of the statement. One part I am reading. That the applicant states that in view of the fact that the order of termination is passed in gross violation of principle of natural justice without following the detailed procedure, this honorable court may take up the sustainability otherwise of the E2 for a breach of the sunset as a preliminary issue. That I have taken. Now, my lord, kindly see there, page 156. Their written statement. Their written statement, in the written statement, they have not said written statement, what they say. 156, my lord, has seen. It says, first it says, with reference to this para 22, they say the statement made in para 21, 22 of the written statement are not correct, hence denied. Next para, that in response to the statement so and so, written statement, the management begs to state that after due inquiry and giving all reasonable opportunity to the applicant, so they have not taken the stay, there was no inquiry. That is why a preliminary issue is required. If they would have said, if it had admitted fact that there was no inquiry, there is no question. Since they have specifically said there was they held an inquiry, so it requires to frame a preliminary issue. That is why I said, why should I say? It is them who should say that if the tribunal finds that there is no inquiry, then that is a question different. Here they specifically said that there was a due inquiry. And nowhere they said, I have read before, I have shown before Lordship the charge, the reply, and the impugned order. There was no inquiry. So when if my little friend says if there is no inquiry, then the question of so they themselves said there was an inquiry. That is why the question arose below. That is why the question arose. And in that judgment, The Supreme Court has held, my lord, in para 8. Para 8, my lord, kindly see paragraph 8.
Karnataka.
Karnataka, para 8.
Hmm.
They have no right as such. It says, before you proceed to examine the question any further, it will be useful to bear in mind the right of the management to lead evidence before the labor court in establishing justification of the decision under consideration by the labor court is not a statutory right. It is a right given by the honorable court, by the law laying down so that yes, they may. Now, my learned friend has referred to the Firestone case. Firestone case, there is no dispute of the law laid down in Firestone case. Yes, they can lead. Firestone case says the management has the opportunity, but they must avail this opportunity at the first instance. I filed my written statement taking specific plea that there was no inquiry. They filed the written statement. They said, yes, there was an inquiry. So it requires an adjudication, whether preliminary issue, whether there was an inquiry or not first. And then if the management says in the written statement that if the court holds that there was no inquiry, we should be given an opportunity, because by knowing that they will not adduce evidence further, I adduce my evidence. Because I adduced my evidence, they cross-examine me. After knowing my case fully well, now they want to improve their case. This is not permissible unless you take your plea. This is plain and simple case. Okay. So, my lord, if lordship so desire, I can and give your lordship a short note of convenience.
Okay, when can you give?
My lord, next week I'll do maybe 10 days, my lord, within 10 days time.
You can give also?
I'll also give.
Okay. Heard Mr.
Clarifying,
T.K. Roy, learned senior counsel, assisted by Mr. S.K.
Yes.
S.K. Chakravarti for the petitioner, and as well as Mr. S. Chakravarti, learned amicus curiae for the respondents.
number 2.
Respondent.
Respond number 2.
Of heard in part, list for further hearing. Give a date. When can you have it? After 10 days, you said?
Yes, my lord, because I'll be out of station.
Okay. 15th?
Lordship.
Is it fine?
That's
Oh, what a-
fine.
okay. That is just for submission.
Lord, man. Obliged, deeply obliged.
Item 13.
Today also.
He is coming, my lord. I had called. He's coming.
It will take 20 minutes. Just 5 minutes. So he told us that it will take 20 minutes.
20
time.
minutes, within 20 minutes he will come.
Where is he?
No.
My lord, maybe taken about second half, my lord. That will be better.
Second half, I've already fixed one matter.
Then
That's also a hearing matter.
Then lost. Hello.
Okay.
I would sometime, my lord, I would wait.
Hmm?
I would sometime, my lord, will come.
20 minutes, who can wait?
How the court can do it is also.
Procedure posted any other day.
Okay, heard A.R. Shektal and the counsel for the petitioner. Also heard K. Gogoi and the standing counsel higher education department, and Mr. A.K. Azad, learned counsel for the respondents, 6, 7, 8, and 9.
My lord may indicate his absence, otherwise.
My lord.
My lord may indicate his absence.
No, none appears for the respond number 10. Heard in part, list the matter again on. Give a date.
As per lordship, 2 minutes.
Six, my lord. Huh? Hearing device. Six.
6 no lage, 6 no lage.
Then 13, my lord.
No, my lord, 13 not possible. Will not be available.
On 15 o'clock.
Lordship,
Yes,
15.
15th. If the respondent number 10 is not represented on the next written full date, It
Yes,
shall
my lord.
proceed ex parte.
My
It
lord,
shall
my lord.
proceed
Briefly obliged.
against
Yes,
the
obliged.
Item 4 and 5.
May it please your lordship.
Yes.
This is otherwise a simple matter. What has happened here, lordship? There are two writ petitions been filed. Now, if your lordship will take up the first writ petition, 8342 of 2022,
8342
of 2022. Oh, okay. Glitch here. If a lordship has taken up that petition, page 18, I'm just showing the prayer, lordship. A, page 17, it starts.
18.
Yes. Directing the respondents to extend the benefit of fixed minimum wage remuneration with dearness allowance to the petitioner at the rate of existing minimum wage entitled by the regular government employees in term with the judgment dated such and such in ATP such and such, and the subsequent notification dated 3/10/2019 issued by the Principal Secretary to the Government of Assam Finance Department. What has happened in this matter? And that notification is at page 30. What has happened? I just place the background. This particular person is working under the Deputy Inspector of Schools in Majuli as a fixed pay casual employee from the year 2000. Now, the amount of pay that he is getting is only rupees 419 per month.
Even now.
Even now. I'll just place it. This was a case of forced employment. He was, in fact, getting nothing. But just because he has the tag of working in a government school, probably as a chokidar, he was working, he was doing his duty from the year 2000. The deputy inspector has written many a time to the director saying that this person needs to be looked into with some sympathy and something has to be done regarding this person because he is rendering service for rupees 419. Now, in the meantime, there was a notification by the government wherein the minimum fixed pay has been indicated. That was on 3rd of October 2019, wherein the amount has been stated to be 15,900 per month. And that should be the minimum pay. So I came up before this honorable court, not seeking regularization primarily, but saying that please give me a dignity of life so that I can live properly. Please give me this. Please give me this minimum wage. So I filed this case. Now, herein this lordship has passed an order asking the authorities to look into it, as well as saying that there will be no bar during the pendency of this writ petition to consider his case in view of the notification. Place does, now lordship will have to take up the second case, how the authorities have thereafter dealt with my case.
Okay. In the
I
next,
just wanted to give the
next case.
next case. I just wanted to give the background as to why the next case has happened. Herein, I will place his documents, lordship. All the documents here, just place the documents. If a lordship will come to page 28.
This is a more comprehensive writ petition.
Everything is here. Okay. Because now I have been terminated. I have been released.
After you filed the writ
After I filed this writ petition. It went to the director. The director told the inspector of schools as to why is this person working in your office? On what basis? You pass an order, you pass a speaking order and deal with him. Now, speaking order didn't come. The inspector of schools directly released me. So therein, they have not followed even the directions of the superiors. And my entire case was this. And there is a judgment of this Honorable High Court Division Bench, Upendas, wherein the government themselves gave an undertaking that people who were working for more than 10 years in casual employees, they will not discontinue their services. They will not be regularized, but they will not discontinue services. And whatever minimum pay they are getting, they should get, they will get. And the Honorable Division Bench have said, yes, go ahead with that. Now, in that view of the matter, treating this person in such an unsympathetic manner probably is what I am before this also. Lordship will probably look into this aspect and find merits in this issue. I only came for minimum wage, and they lashed the whip, released me. And therein also, they didn't follow any procedure. Director said, pass a speaking order. Inspector of schools simply released me. Therein also there is a lacuna. So if I may therefore now place the documents, everything will be clear, Lordship. This is the small issue, Lordship. A small person like this should not be treated by a mighty department in this manner.
First of all, he was not appointed
No,
by
both
the
take
department.
No, he has not finished.
Page 28, Lordship. This is an order of the Inspector of Schools. There are several orders, Lordship, separate orders. I'm just placing one of the orders that is with me. Sri Tonkeshwar Borua, inhabitant such and such, is temporarily engaged on daily wages in the office of the Deputy Inspector of Schools from 1st of February 2000. This engagement is purely temporary, and Sri Tonkeshwar Borua will draw his wages of rupees 5,448 of 365 days. So in a year, he is getting 5,448. And the expenditure is debitable under the heads of accounts for the financial year 2018-19. This is signed by the Deputy Inspector of Schools, Majuli, and a copy has been given to the Director of Elementary Education, Assam, Kahilipara. But we've seen that. Similar orders are there at page 29, page 30.
This, what does it mean, this 5,448 of 365 days? So that means in a year.
In a year. 5,448 rupees in a year.
In a year.
In a year. Later on, they have given that particular base amount. I'll produce that document also. Now, if your Lordship will come, because temporary employment, Lordship knows they give a break. They give separate orders. Now at page 32, page 32. This is to certify that Tonkeshwar Borua, son of so-and-so, village so-and-so, having class 9 pass qualification, who has been serving as casual employee, engaged by the then Deputy Inspector of Schools, Majuli, in the office of the Deputy Inspector of Schools, Kamalabari, since 1/2/2000, and till date, have been paid a lump sum amount of rupees as per allotment. They do not write the rupees, as per allotment of fund received by the DE Assam, Kahilipara. He is obedient, sincere, regular, faithful. He always keeps the office clean and nourishes the flower garden, which enriches the natural beauty of the office campus. Considering the sincerity of service, he may be regularized against the post lying vacant due to expiry of one Sri Nobin Soikia, Night Sokidar. Now, if your Lordship will come to page 37. A formal move was made by the Deputy Inspector for his regularization. I'll just place those documents in 2017. On 18/11/2017, Deputy Inspector of Schools writes to the Director of Elementary Education, with reference to the subject cited above, I have the honor to forward the petition of Sri Tonkeshwar Borua in connection with fixed pay workers under the Deputy Inspector of Schools, Majuli. Now, if your Lordship will come to page 38, it gives a better understanding of his position. Page 38. Statement regarding the casual employees in respect of the office of the Deputy Inspector of Schools, Majuli. Now, Lordship will see Department Elementary Education, name of the incumbent Tonkeshwar Borua, date of engagement 1/2/2000, length of service 17 years, 8 months, 3 days, scale of pay, amount fixed, rupees 416 per month, fixed pay. At page 39, if your Lordship will see, page 39, the Deputy Secretary of the Government of Assam, Chief Minister's Secretariat, writes to the Commissioner Secretary Elementary Education, kindly find herewith a letter in original issued received by Headmaster so-and-so school, a letter received by Additional Deputy Commissioner Majuli, a letter received from Sri Tonkeshwar Borua, and a letter by Sri so-and-so Secretary, this, self-explanatory. You are requested to examine the matter and take appropriate steps as per rule from your end, and action taken in this regard may kindly be intimated to the department. So there was otherwise a move in the department itself that this person is working for more than 17 years and the amount is only 416 rupees. So therefore, regarding this fixation of his minimum pay, some decision should be taken. So correspondence is going on. Now the notification is at page 41. As we have seen that, page 41.
Yes.
This is issued by the Finance Department, dated 3rd of October 2019. Now it says, in supersession of the Finance Department's earlier notification, the following are hereby notified for compliance of all the state government departments as applicable for the muster roll, work charge, casual employees, and similarly placed employees who are engaged prior to the FRBM period of 1st of September 2005. And the amount fixed is the fixed wages remuneration of rupees 15,900 with dearness allowance will be admissible, which will undergo revision whenever pay scale changes based on enhancement of DA and a recommendation by the Pay Commission, along with medical allowances of rupees 600 per month. So this notification squarely covers my case because it says regarding all muster roll, work charge, and casual employees who were engaged prior to 1st of September 2005. Rossi had seen that my engagement is in the year 2000, 1 to 2000. And so therefore, for people of this nature, the amount fixed is 15,900. So just claiming this amount, I filed the first writ petition saying that there is a circular, a government notification, please pay me that. Now Lordship will see thereafter, page 44, the order that was passed in the first case.
Okay.
Now notices were issued and the last paragraph Lordship will see at page 46. Pendency of this writ petition shall not be a bar for the respondent authorities to provide the petitioner the amount entitled by him in terms of the decision taken in the state of Assam versus Upendas. But there's also a judgment. I'll just place the judgment also. Now thereafter, at page 47, I give a representation to the authorities stating about my situation. Then your Lordship will come to page 54. Another interlocutory order took place in between. Page 54. This is dated 28th of March 2023. The elementary education sought for time to file their affidavit in that case. Now Lordship will come to page 56. What in the meantime the authorities have been doing. So this is the letter impugned along with another. I'm just reading this slowly, Your Lordship. Page 56, last page. This is dated 5th of March 2023 and has been issued by the Director Elementary Education to the Deputy Inspector of Schools, Majuli. With reference to the subject cited above, I would like to inform you that Tonkeshwar Borua under Majuli district has filed a case before the Honorable High Court bearing WPC number 8342 of 2022 to extend the benefit of fixed minimum wages remuneration in the current post of night chowkidar in the office of the DIS Majuli till his normal superannuation age. In this regard, the parawise report as received from your end by letter under reference, it is shown that the petitioner was temporarily engaged on daily basis in the office of the DIS Majuli from 1/2/2000 as per the order of the DIS Majuli dated such and such, such and such and such. But no formal appointment letter was issued by the competent authority. The appointing authority is the Director of Elementary Education, Assam. Further, there is no government provision for any such private engagement by the officers. Therefore, such engagements done by the DIS Majuli is illegal and violation of the provisions of the government guideline. So, you are hereby asked as to how a private person was engaged in your office establishment by violating the government notification issued from time to time. You are also directed to take immediate and stringent steps to release the private person from your office by issuing a speaking order as per the government rules and procedures. The action taken report should reach the Directorate on or before 18/4/2023. And this was of 5th of March 2023. Now page 55, what the Deputy Inspector of Schools does in the most arbitrary and mechanical manner. Page 55. The just space before that, Lordship.
Okay.
Page 55.
Hmm.
That arrangement of page, there was some mistake, Lordship. On 18/4/2023, this is what he does. As per letter received from the Director Elementary Education, White letter number such and such 5/3/2023, Sri Tonkeshwar Borua is hereby released from all the temporary engagements at the office of the Deputy Inspector of Schools, Majuli, and this order comes to force with immediate effect. Without any proper exercise of mine, his authority, without even passing a speaking order, even without allowing me an opportunity to be heard, and mechanical order, an arbitrary order, a high-handed order of this nature has been passed, directly releasing me. And this Deputy Inspector himself has been writing all along that I should be entitled to that minimum basic wage. And just because he has to now therefore please his superiors, he passes this order without following any norms. Because the director also said, pass a speaking order, and speaking order would presuppose allowing me an opportunity to be heard. Without that, can I
What date is this?
Lordship?
What?
Date is 18/4/2023.
18/4.
Yes, he waited all this time because the letter of the director was of 5th of March and the compliance was supposed to be filed on 18 April. Deputy Inspector didn't do anything. On April 4, when he saw that the time was ending, nothing to do, he just passed this order. Stroke of pen, I am out. While all these documents and all these issues were just nullified, put to a nullity. This is my case. And then now the issue regarding whether casual employees can continue or not. There have been series of litigations in this honorable court from a long time. State governments have been always appointing muster roll workers, work charge, and casual employees. Now, people have come before this honorable high court at many a times seeking regularization. Some cases, government have passed decisions, policy decisions to regularize, to absorb. Before 1993, all muster roll employees have been regularized. Post that, it was said that they will continue in the same fashion and they will end, their post will end. Supernumerary post will end along with them. They will not be regularized, but basic pays will be given. There is a judgment of this honorable division bench wherein in Upendas, people of this nature came before this court. And then the court said that no, Uma Devi judgment may not be applicable for everyone. But then people who have been working for a long period, the government should take a call on them. And then the government had taken an undertaking, the last paragraph of Upendas, that the government says all casual employees, work charge, master roles in various departments of the state who have been working for more than 10 years, we are not going to discontinue their services. They are basically Hajirar laborers, will not discontinue their services. They will be getting the minimum pay of scale. And once their age of superannuation comes, it will end with that. And that observation is there in Upenda's judgment. I'll place that. I think Lordship will be rising.
5 minutes.
Yes, Lordship. Yes, Lordship. Actually, I had placed the issue. Just one interim order of this honorable court in this writ petition dated 8/12/2023. 8/12/2023.
Yes.
Just read that order. The respondent in the elementary education department to file their affidavit on the claim of the petitioner for the minimum wages as claimed in WBC number 2976 of 2023. Till such affidavit is filed and the matter is taken up on the next day, the service of the petitioner be not discontinued.
So you are still continuing?
No, Lordship. They have not allowed me to join. No salary, nothing. This is how discriminating and harassing their response has been in my case. Just to indicate that aspect also. Even though I have an interim order in my favor, nothing. No salary, nothing. Anyway, Lordship, I'll just place the judgments. 2 judgments, Lordship. First judgment, Sri Muhammad Amjad. I'm just referring to one paragraph, paragraph 25. This basically to deal with the aspect that when the court is in session of a particular matter, there cannot be a parallel adjudication by the government. The division bench of this honorable court in such and such has held that when the court is in session of a matter, An administrative authority cannot start a parallel proceeding on the very same subject and record a finding. It will amount to interfering with the dispensation of justice by the court. Only on this limited aspect, because in that particular matter, Lordship has seen the first matter, the issue was regarding my minimum wage. Now, when that matter went to the director initiated a parallel proceeding, and thereby circumventing the court's adjudicating authority, he passes an order, thereby creating a completely different situation, which he cannot do in view of this judgment. Only on that aspect. How the director's communication, or for that matter, the inspector's communication, would be in direct interference with the dispensation of justice of this honorable court. Now, regarding the other judgment, Upendas, this is a division bench judgment, and this was a case regarding regularization, entitlement of master roll, work charge, and all casual employees in the state of Assam. The last paragraph, paragraph 22. It is, however, heartening to learn that the state government has agreed not to terminate the master roll workers and similarly place employees working since last more than 10 years, not in sanction post, till their normal retirement, except on disciplinary ground or on grounds of criminal offences. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as a welfare measure for the betterment and the security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Beside this, we, in the light of the decision of the Supreme Court in State of Punjab versus Jagjit Singh, also direct the state government to pay the minimum scale of pay to master roll workers, workers, and similarly place employees working since last more than 10 years, not in sanction post, with effect from 1/8/2017. I therefore also squarely fall under this directions of this honorable division bench. Because they say before 10 years, I am from 2000. So this judgment was passed in the year 2020. Yes, 2020. So that's 10 years. If we turn the clock back to 2010, but I am from 2000. So an employee who is now effectively like 25 years now, if this discontinued period is also counted, has been sought to be treated in this manner. So therefore, my humble submission to the Lordship would be, number one, since they have not exercised the proper mode of terminating me, because what they have said, speaking order, there was no speaking order. Speaking order would mean presuppose that I am given an opportunity of hearing. Natural justice has not been followed. Directly, one order, I am released. So therefore, the order is bad on that count itself. That is number one. Therefore, I pray for Lordship that that order should be interfered with. I may be reinstated. In my position, I am asking for regularization. And in the first case, where I am seeking for a minimum wage, that should be given to me till the time, if so advised by the authorities, they initiate a process against me by following the due process of law. I cannot stop them from doing that, because that will be a subject to another judicial scrutiny. So therefore, that is what I pray for, Lordship. This person working for so long should not be treated in this manner. And if I may say, Lordship, it's not supposed to be told in this court, off the record, he doesn't have anything now. I mean, we are also doing it pro bono. He doesn't have anything. This way, a person should not be treated by a mighty department, wherein in Upendas, they have got a word of appreciation from this honorable division bench, saying that we will not terminate, we will not do anything. And why are they doing this with this person then? In fact, contemptuous of this observation of this court also. This is my submission also. On merit, I am not saying. Their ground is directors should have issued the order, deputy inspectors should not have issued this order. But deputy inspectors' orders were all communicated to the director. The copy markings are there. Today, they just woke up from the slumber and they say this is not in accordance with law, and therefore we are issuing this order. That should not be the approach by the department.
Okay.
My lord, first of all, we have not appointed the person, my lord.
Copy was served on you.
Yes, ma'am. So,
Copy of his appointment was served on you.
Lord, we have not appointed the person. And my lord, one officer for the personal purpose, he was appointed. And my now he was not in service, he was already retired.
Who?
The concerned officer, man.
Oh, that's a different thing.
Yes, ma'am. My lord,
Just see the appointment order.
we have already filed our affidavit.
Mm.
So my lord, kindly see para 6 of our affidavit, my lord, page 59.
Mm.
That with regard to the statement made in para 4 of the writ petition, it is to be mentioned here that a certificate was issued by the Deputy Inspector of Schools Majuli on 8/2/2013, wherein it is stated that the petitioner has been serving as a casual employee since 1/2/2000, and he has been paid a lump sum of rupees as per allotment of fund received from the Director of Elementary Education, Assam, but no formal appointment was issued from any competent authority. Further, the Deputy Inspector of Schools is not the competent authority to engage any private person in office or school engagement as per government rules. There is no such government provisions for direct recruitment by the Deputy Inspector of Schools. Therefore, the engagement a private person in a government establishment is illegal and in violation of government rules and procedure. Hence, the petitioner cannot claim for regulation of his service. On the other hand, the petitioner was not engaged in any sanctioned post. He was rather engaged as a wages in a lump sum daily basis. Para 7, that with regard to the statements made in paragraph 5 of the writ petition, the answering deponent respectfully begs to state that the petitioner was not appointed by the competent authority as per the government rules and procedure. Further, no formal appointment order was issued to the petitioner by the competent authority. Engagement of a private person in government establishment without following the existing government rules and procedure is illegal, invalid, and a violate of government rule. Therefore, he was released by the Deputy Inspector of Schools Mazuli on 18/4/2023 as by instruction of the Director of Elementary Education, Assam, by letter so and so. So, my lord, he was not appointed by the
You
department.
are filing your affidavit in opposition just for the sake of filing it. Number one,
Mm.
when the petitioner was appointed by the Deputy Inspector of Schools, a copy was forwarded to you. You did not take any steps. You kept on waiting. Then when the petitioner came before this court praying for the minimum wages, then you issued a direction to the Deputy Inspector of Schools to terminate the petitioner after passing a speaking order.
Mm.
He did not pass a speaking order. And in your affidavit, you are saying that he passed the order as per the direction of the director. Has the Deputy Inspector passed a speaking order?
My lord. My lord, here, my lord, all those letters which was issued to the Director of Elementary Education, my
Maybe
lord.
the appointment of the petitioner
My lord.
legally may not be sustainable. All right.
Hmm.
But one thing which goes in his favor is when he was appointed, a copy was endorsed to you.
My-
You kept silent. Why did you keep silent?
My lord,
Why did you keep silent?
whether they have received or not, my lord,
That
these
I don't
all
know.
those copies, my lord, I have to take it up.
I don't know about that. What difference would it make if you get an instructions?
My lord, I have to receive that instruction, whether they have received on all those orders.
You would say you'll come back with the saying that we never got a copy of these orders.
My lord, if they had not received all those orders, so how can a person?
The other thing is,
Hmm.
when the petitioner filed a writ petition praying for minimum wages, instead of filing an affidavit
Hmm.
saying that no, he is not entitled to this minimum wages because of so and so reasons, you take another step to terminate the petitioner. Is that also legally sustainable?
Look, because his entry is totally illegal, man.
So you should have filed an affidavit
Mm.
saying that his entry is totally legal and therefore he's not entitled to this minimum wages. What did you do? You proceeded to terminate the petitioner.
So Malad, can you give up some time to
What
further
the,
all those orders were received or not by the director, office
what
of the
difference
director?
will it make?
Malad,
I have a submission on
I
this.
have to
Lordship.
talk with them, Malad. No
This
need,
is
Malad.
this is only a time-taking tactics. The legal argument for this would be these documents are all in the writ petition. Now, based on what is in the writ petition, they have filed their affidavit in opposition, knowing very well that these letters are there in the writ petition. They will not be given a further chance now to better their case by filing any supplementary affidavit or bringing any verbal instructions.
See, that's why I'm
Because these
saying
documents are already there, they filed their objection.
in the writ petition, these documents are already there. Correct. You could have said that this was never, we never got
That
a
is not
copy
their
of that
ground in the
order.
affidavit.
Nothing, there's not a single whisper.
So therefore, they may not be allowed this chance now. And one more aspect, 2017 also, the letter was written by the delivery inspector. 2017 for that minimum wage, page 37. From 17 also, they have not taken, maybe 2000, year 2000 document, they are saying they don't know. 2017, the deputy inspector formally writes to the director, giving the entire biodata of the petitioner, saying that he is entitled to minimum wages. 17, they don't do anything. When they move, when the first writ petition in 2022 was filed, this also belies what she is saying now. Now, therefore, giving them a chance is not there. It's an open and shut case that national justice was not followed. And I was just victimized because I came to this honorable court.
Talk with the director.
Talk now.
Malad, can be sometime maybe about Malad.
Urgent matter.
I'll give you.
Today is holiday, Malad.
What holiday?
Today is holiday, state holiday.
Is it a state holiday?
Yes, no.
May 1 is a state holiday. We don't get a holiday, they get a holiday.
Okay.
So, be that as it may, even if the instruction comes that this document is not with them,
Hmm.
still, I am saying,
No, Fukan, I've made my mind very clear. The order of termination is bad. For two reasons. Petitioner was not given an opportunity of hearing. Number two, the deputy inspector of schools did not pass a speaking order. That's all. So you reinstate him back.
No, Malad.
and that interim order was also there. Not
Directly,
in
we
this one.
cannot reinstate him because as per the establishment, Assam Ministerial District Establishment Rule, Malad, there is nothing any establishment rule. There is nothing any settled rule, Malad, for the appointment of peon, Malad. So
How
as
old are you?
Ministerial
50 years, Lordship, when this writ petition was filed in 2023. Now I think 52. At this stage, and Lordship, what about their undertaking in Upenda's
we
case?
have the post as per to proper advertise.
No. It's not. It's not.
That's a different issue.
not a fact.
That's
Thousands of employees as work stars,
up to
casual
you. What
employees.
you want to do, you do. But then see this Obinda's judgment that para 22 or 23,
22, Lordship.
22. It's also clear.
They will not discontinue this.
Of course, the entry into service of the petitioner, that what the director is saying, that it is the director who's the competent authority to issue the appointment order. But then that part also, when the deputy inspector of schools appointed the petitioner and his term was extended year to year, all these documents were handed over to you. I mean, a copy was endorsed to you. You did nothing. When the deputy inspector of schools processed the case of the petitioner for paying the minimum wages, you did nothing. Then he comes to court praying for that minimum wages. Then suddenly you say, okay, you're trying to challenge my authority in the court. That's basically what this court is understanding.
Exactly, that has
You're
happened.
trying to challenge my authority, you get out.
Yes, exactly.
That's what he did.
So my lord, kindly sometime you be allowed, my lord.
What time?
No, my lord, and I have to go through these judgments also. So my-
Obindas, it's a very old judgment.
Correct, Lord.
my lord, I have
Very
to-
old judgment.
I have-
Everybody knows what is Obindas.
Upenda.
Maybe I have to go through these judgments also, and I have to talk with the director. Whether they have received or
Can we
not, my lord,
reopen
all
these
those-
issues now
my
after
lord,
the affidavit
why-
is filed by them? I have filed my reply.
Asking for time, my lord. But
When did I
today
ask
I
for
am, today I am asking for time. my lord. Today I am paying for time. What is problem?
Okay, we give him a short time. So
The
let
Lordship will
him
make the matter part heard. After Lordship has already heard this matter.
Shyama Leonard, counsel for the petition. On request made by MS Nfukan, Leonard Standing Counsel,
Elementary.
Elementary Education Department. When do you want?
After 1 week,
After 1 week. Today's first. 13th
Your Lordship's convenience any date?
as part.
But Lordship will give it a part. Yes, Lord.
See, this thing you are applying for,
Respondent number 7, my lord.
who's there? Who's any?
Accountant General.
Okay.
For that minimum wage.
MS.
S. Sharma on behalf of Bishop.
Shyama Leonard, counsel, bring on your address to the accounting general.
Lordship has kept it part heard. Obliged, Lord.
No, we'll have it 15th. 15th.
my lord.
13th, I've got many cases fixed.
I'll leave it to your Lordship. Obliged.
Item 6 for hearing.
This is your Lordship. Lordship, we misplaced our file regarding during the time of shifting. Kindly give us 2 weeks time to reconstruct the matter.
Okay, on request made by Mr.
M. Khan on behalf of AR Bhuya.
Request made on behalf of Mr. Air Buyan, then counsel of the petitioner. List the matter after 2 weeks. You've still not got your file. March also, that same ground was taken.
Item 9.
My pleasure, Lord. Lordship, this is a case of promotion from junior assistant professor to assistant professor, Lordship. I was.
In this case, Lordship, better placed before state level committee, Lordship. And there's a lot of cases in there. I talked to Gogoi, Lordship, and there's some more time required, Lordship. After summer vacation, matter may fix, Lordship. In the meantime,
No. What are you trying to say? You have placed the case of the petitioner
yes,
before,
petitioner along with others in
before the state level
Lordship,
committee.
Lordship. Lordship.
For
For the consideration,
If I may submit, Lordship,
what I
earlier, my BST was being questioned by them whether it is union or not. And the university has already given a confirmation. I have a letter of the university, Lord. And I think they have no dispute in this regard.
Deprive of the due entitled amount till this.
the process is on, Lordship. That's why. Then there not one more than several cases, more than 1,000, I think. Lordship. There's a time sometime.
But I have been deprived in today, Lordship, of this due amount.
Lordship,
Since I have
all
already
the
acquired
matters,
this in due
that's why
course of
time
time.
is required, Lordship. I talked to Gogoi, Lordship. I could direct, I talked to Gogoi, after
But they
vacation,
cannot
summer
club both the
vacation,
matters together, no, Lordship.
they'll get definitely. One state level committee is there.
When I have done all the requirements, I have been deprived of my entitlements till today.
There are a lot of cases there. That's why time is required.
Lordship, I give a time frame and then dispose of the matter. Otherwise, there is no
Lordship,
dispute in this matter.
I have talked to Gogoi, Lordship. Gogoi had.
who's Gogoi?
K Gogoi, Lordship. I talked to with department, Lordship. I am submitting on his instruction that there is some time required for the department, Lordship, because there are a lot of cases, similar thing, Lordship, going on. That's why.
No, lot of cases. See,
That's why.
They should not mix up this case.
petitioner is before this court because he got his PhD, and after receiving the PhD, he has requested for promotion.
Yes, sir.
That request is still not considered.
Yes.
That is what this court is, this
assistant
petitioner is saying.
assistant professor Lordship. But I am handling back some
They have taken enough time, Lordship, in this matter.
after 8 months.
Lordship may kindly observe it and this was it out.
And sometime is required.
Who is Gogoi?
I think may call him or sometime in the
Bring him, let us hear what he has heard from his department.
Lordship.
Because you are the third party, you are the
Lordship.
third person.
Lordship. Timing, Lordship. And
Call him, call him.
Salary automatic.
Hmm.
Salary is automatic. No, no. The Lordship comes to page 25, wherein this entitlement comes from. Page 25 is the order dated 5th of February. It's a very small font, Lordship. I'm sorry for that. 5th of February 2021. Now, it's an order of provincialization, wherein Lordship will see my name at the table, serial number 9, the last, Dipanjali Devi. So, I am working in the post of tutor, assistant professor for a particular pay scale of 27,000. And now, if your Lordship will see terms and conditions, serial number 6, wherein the entitlement comes. Any tutor principal, tutor assistant professor who has already acquired the qualification required as per UGC norms and service rules in force on the date of issue of his or her provincialization order shall be entitled to pay and allowances of a principal assistant professor from the date of issue of such provincialization order, provided tutor principal, tutor assistant professor who acquires such qualification within 5 years from the date of issue of his or her provincialization order shall also be entitled to pay and allowances equal to principal assistant professor with effect from the date of acquiring such qualification as per the relevant rules for the time being in force. So the issue is not promotion. The issue is basically the entitlement of a higher incremental pay scale. So therefore it says if you are a tutor and if you have been able to obtain a PhD within 5 years or a provincialization order, then you are getting that enhanced pay scale of a assistant professor. So here it is a case wherein I have produced before this honorable court now, which I have already produced before authorities, that I have my PhD degree from Magadh University. Now the issue at one point of time before this honorable court was that this certificate may not be true. That verification has already now come. And they say that this is a genuine certificate issued in favor of the petitioner. So therefore, the flow of this entitlement comes automatically as per this order. So what is there to be further go for the state level committee and anything?
Yeah, Buyan.
Pogo is coming, Lord, sir.
See, this order of annexure 2, 5th February 2021, which is issued by the Director at Higher Education.
It's an automatic flow of benefit.
Clause 6 of the terms and conditions.
Page 25 of the petition. Page 25 repeating. Have you filed there?
Clause 6.
How?
Have you filed in the affidavit?
What does the affidavit say?
Earlier, they have been taking time saying that they are verifying this document. Now, this has come from the controller. This has now come from the controller of the Magadh University to the Director of Higher Education, and they have certified this. Affidavit paragraph 7, they had said
6. Paragraph 6.
Yes, Lord. I'm obliged, Lord. Paragraph 6.
Before we start with
I was just waiting for you.
Lordship,
Tell me.
in this case, Lordship, there was a committee five-part committee was constituted, Lordship, as per Honorable Court's direction. Lordship. That committee submitted the report, Lordship. After that, also, all the persons were doubtful PhD, Lordship. They asked to submit the documents. Lordship. Document verification already completed, Lordship. It was now placed before the Lordship state level committee. So my Lord may posted the matter, Lordship, after summer vacation. In the meantime, Lordship, the report will come, Lordship.
No, see, one thing is this.
Lordship. Otherwise,
The
Lordship,
petitioner's certificate has found to be genuine.
Lordship.
Correct. In terms of the high power committee investigation. Now, when the petition was provincialized by the order of February 2021, there's a clause at para 6 in the terms and conditions clause 6, which provides that if you get your degree or PhD degree within 5 years,
Yes,
you will be entitled to higher pay scale.
Lordship.
shall also be entitled to pay. Yes, automatically.
That is their Lordship. But Lordship, the PhD should be Lordship as per the Lordship UGC Lordship criteria prescribed by the UGC. But the Magot University, where he has taken Lordship, one of the pillars that it was by the Lordship bylaw of the Magot University, Lordship. That Magot University, the bylaw that is the not actually that bylaw was Lordship, it is a draft rule, Lordship. Draft rule is there, Lordship. I admitted there is a draft rule. But Lordship, the course which was taken, Lordship, it is by violating the Lordship, the criteria given by the UGC Lordship.
That is not their ground in their affidavit.
Now, I will place it everything, Lordship.
However, the directorate is yet to receive the authentic report from Magot University. The only issue in the affidavit was the genuineness. These are all new things coming up now.
That is not new things, Lordship. It is as per our
I'll
High
go
Court
by the
judgment.
affidavit.
I have High Court judgment also, Lordship. If necessary, I will place another affidavit. We can also file it, Lordship, if Lordship required. Otherwise, Lordship, I will place our case, Lordship. Lordship may posted the matter, Lordship, after summer vacation, Lordship. In the meantime, report will come, Lordship. Not only
See,
petitioner, Lordship.
Your affidavit in para 6.
Lordship.
It's very clear.
No.
The director.
No. Okay, para 6 talks about the
Lordship.
fake PhD degree and whatever it is,
Lordship.
the doubtful ones.
Yes,
Lordship.
Lordship.
Then come to 7.
Lordship.
Yes. Para 7.
Para 7 as per existing law, act and laws, Lordship. So that's why, Lordship, it is placed the Lordship, the SLC, Lordship, for final outcome, Lordship. After that, Lordship, we'll act it upon, Lordship. That is the reason, Lordship.
How long will you take?
Lordship.
How long have you been after you got your PhD? 7 years? No, I think it must be 9 years.
Yes.
If Lordship,
No.
No, 22 Lordship.
22.
So for last 3 years, I've not been getting my pay scale, the due pay scale.
Lordship, if she is success, everything will, she will get, Lordship. Last 3 years, every area will be get, Lordship. Everything will be getting. It is not that, Lordship, she will not get anything, Lordship. It is not a case that she is not getting anything. She will.
I won't go up to summer vacation.
Lordship.
I'll give you 1 month.
Let them place our case before a lawsuit, because what they're saying is it's bundled with thousands of cases. Let that not happen. I'm before this honorable court. The others are not. Let this case get some priority.
Lordship will do. Otherwise, all the cases are placed before the SLC, Lordship. See, odd numbers of 700 or 800, Lordship.
Okay, heard A. Sharma, learned counsel for the petitioner. You will appear? Mr. K. Gogoi, learned standing counsel higher education submits that the case of the petitioner, along with several others, has been placed before the state level committee, which would take some time.
So, my Lord may post it immediately after summer. In the meantime, Lordship, it will come.
He accordingly press for time to permit the state level committee to take a proper decision in the matter. Stop. Accordingly, list this matter.
Immediately after sir, already I have informed my children. Then otherwise, Lordship.
Our case may be treated with priority by the SLC and report may be submitted.
Will do.
It should not get lost in those sea of other cases.
After the summer vacation.
And also will observe that the report may be placed before this honorable court on that day.
The report of the SLC shall be placed before this court by the next written. Okay.
And Lordship is giving any date. Any date.
I'm just saying after the summer vacation.
Some date may be given.
When is the summer vacation?
Lordship, week commencing from Lordship 21, Lordship may give it, week commencing from 21, any day, Lordship.
22nd.
Yes,
Lordship, 22nd.
22nd.
22nd July.
20.
This type of small matters.
Lordship.
Yes, Lordship.
Otherwise, she will, if that report is come, she will get everything, Lordship. It is not that, so
No,
it's
it's
not.
not.
Delaying it is
She's
also-
getting in but the tension, the anxiety that you are
That is
letting
there,
her go through. That also is another thing.
That is there,
That's
that is
not.
there. The issue is that, Lordship, as per court's direction, we have done it, Lordship. It has come to the knowledge of the Honorable Court that, Lordship, so many things is happening in the higher education department, Lordship. At that relevant point of time, already I have indicated, Lordship, that during the tenure of the one particular director, Lordship. That's why
What have you done against him?
already, Lordship, he was replaced it and DPS going on, Lordship.
Which will never end.
DPS going on, Lordship.
Which will never end.
Not only one DP, 3 DPS going on, Lordship, against that particular person, Lordship.
How can you have 3 people?
Lordship, not only in this case, Lordship, but separate issues, Lordship. Separate issues.
Final disposal, or my learned friend will argue his.
No,
Last time understanding was, we'll go for final.
No, you have, my senior had argued his part. I have placed my submission. Lordship wanted to have a look at the IA that was filed in 5870. IA for modification of the interim order passed on 4/10/2023.
আর move on. সেইটোৱে না? আয়াটো আহিছে না?
That one we directed to one
IA to be
IA to be listed.
yes, and that IA pertains to
5870 of 2023.
Yes,
Is it listed?
yes.
And kindly have a look at the orders, my lord, passed in that IA.
No, that's why we directed that IA to be listed.
Yes, ma'am.
I don't know whether this.
It has been listed. It
Huh?
has been listed.
Even otherwise, I have copy, my lord.
No, it is not listed.
Dispose of matter to আহিছে।
Just check up one IA 3252 of 2023.
The entire case is
কেছৰ থাকিলে লগতে থাকেতো।
3252. Okay, yeah. it's
Yes.
here.
that IA was filed by the writ petitioner for my lord suspension of the order dated 4/10/2023 by which NOAs were issued to 5 of the bidders in respect of 6 tankers.
No, for what reason you wanted this IA?
Yes.
My lord, I am relying on an order passed by this honorable court for modification of the interim order. Now, because interim order was passed on 4/10/23 and the NOAs in respect of 5 bidders for 6 tankers were also issued on 4/10/23. Challenging that notification of award, which includes the award given to the present writ petitioner, this IA was filed and this honorable court did not pass any order staying those NOAs. Now, because if your lordship takes up my stay vacating application at page 34, there is an order
In the present case.
present writ petition. We have filed one IA for vacating the interim order. At page 34, lordship will see the order passed by this honorable court clarifying the interim order dated 4/10/23. Now here, this honorable court, while passing that order at paragraph 3, without going into a determination as to whether a work order is issued, we clarify our interim order dated 4/10/23 that the expression shall not undertake any further process means that if the work order was not issued as on 4/10/23, the same shall not be issued. And if issued, it shall not be acted upon. We clarify that the interim order dated 4/10/23 shall be in respect of only those tenders where the petitioner has participated. Now, my lord, the tender is one. Tender is one where the requirement was for 8 tankers. That petitioner, Mahmood Ali, had submitted his bid in respect of 2 tankers. That is why interpreting this order, as it has been clarified, since there was only 1 tender, there is no question of several tenders. 1 tender, 2 bids in respect of 2 tankers. That is why we have issued NOA in respect of 5 bidders in respect of 6 tankers, but the bid submitted by Mahmood Ali in respect of 2 tankers were not issued. That is why our submission before your lordship is on 4/10/2023, when the NOAs were issued in respect of other bidders, including the present writ petitioner, these NOAs were never put under stay by this honorable court. And since that NOA was a valid NOA, and if your lordship says,
Chakrabarti, if I'm not wrong, it's been quite some time, so
My lord.
it escaped my mind. Did we not decide to dispose of the whole thing?
yes, my lord.
Writ petition.
Yes. And accordingly, my lord, arguments on the merit of the case was advanced by my senior colleague, and I have also submitted our argument.
Okay.
Now, if your lordship sees the contract, the bid document at page 64.
Writ petition.
Yes, my lord. 33.0. Last 33.0 notification of award. What this NOA literally means, my lord. Prior to the expiry of the period of bid validity, the ONGC will notify the successful bidder in writing that his bid has been accepted. Then at page 65, 33.2, the notification of award will constitute the formation of the contract. So, my lord, this NOA itself is part of the contract. Though the contract is required to be signed within a particular period, but NOA is contract was not signed because the contract was not signed, but NOA itself will constitute the formation of the contract. So this NOA will be binding upon the parties. And as per the NOA, since the petitioner had given a lesser period for mobilization, the petitioner had undertaken to mobilize the tanker within 59 days, and that is why he was selected. As per the NOA, he was supposed to mobilize within 59 days, which he failed. So, my lord, this NOA was never under stay. This NOA was binding between ONGC and the writ petitioner, and the writ petitioner, as per the NOA, failed to discharge his duty. Now, my lord, on 16/1/2024, when the contract was terminated, my lord, there was a period of 103 days from the date of issuance of the NOA. Under the NOA, the period of mobilization was 59 days. So, from NOA, he was supposed to mobilize, place the tanker within 59 days. He did not. And on 16/1/24, it was 103 days when this NOA was terminated. Now, my lord, on 16/1/24, the other writ petition was not decided. The fact of cancellation or the passing of that order by this honorable court in 5870 of 23 was not there. So, this order was not a relevant factor for consideration of ONGC at that point of time when the termination order was issued. Now, if the NOA was valid on 16/1/24 and if the NOA was terminated for non-fulfillment on the part of the contractor, then this termination is not illegal. Now the question comes, if the termination is valid, under the contract, as a consequence of termination, the ONGC can put someone or the erring contractor on holiday. The termination was never challenged at that point of time. It is only when this banning order, provisional banning order was issued, it has come before this court by way of a writ petition. Now, I'll take your lordship to that part of the contract which says, as a consequence of termination, banning can be done. If your lordship comes to page 122, clause 18, termination. And at page 123, 18.5, termination for delay in mobilization. Successful bidder be required to mobilize complete equipment with crew for commencement of service at the specified site within a maximum period of 90 days from the date of the NOA. If the contractor fails to mobilize as above, NJC shall have, without prejudice to any other clause of the contract, the right to terminate the contract. Now, my lord, here the 90 days is my lord, here the 90 days specified is for general situation. Now, here it is an exceptional situation because there was a tie among the bidders and the tie had to be resolved taking into account the shortest minimum period of mobilization. And there is an undertaking on the part of the contractor that he will mobilize within 59 days. Based on that undertaking, his bid was not only accepted, he was selected. So this 90 days here will be considered as 59 days because NOA is very specific about the number of days within which mobilization is to take effect. Now, so the factual position is he failed to mobilize within 59 days. Now, it has as a result of non-mobilization or not mobilization within the period specified in NOA, contract was terminated. Now, lordship will come to pay this 18.6, consequence of termination. And this situation is covered by 18.6 Roman 2. Pending completion process for putting the contractor on holiday, ONGC shall neither issue any tender inquiry to the defaulting contractor nor shall consider their offer in any ongoing tender. 18.6 says, in case of termination herein set forth, except under 18.1 and 18.2 and or annulment of the contract due to non-submission of performance security, following action shall be taken against the contractor. 1. ONGC shall conduct an inquiry against the contractor and consequent to the conclusion of the inquiry, if it is found that the fault is on the part of the contractor, then they shall be put on holiday. That is, neither any tender inquiry will be issued to such contractor by ONGC against any type of tender, nor their offer will be considered by ONGC against any ongoing tenders where contract between ONGC and where contract under the particular contract has not been concluded for a period of 2 years from the date of the order of putting the contractor on holiday is issued. However, the action taken by ONGC for putting that contractor on holiday shall not have any effect on other ongoing contracts. So, as a consequence of termination, my lord, the ANGC under the contract, under this tender has the right to put a contractor on holiday. And to pass that order, an inquiry will have to be conducted wherein the contractor will be given the opportunity to defend and answer or reply his version. And upon inquiry, if it is found that there is fault on the contract will be terminated. The contract will be put on holiday for a period of 2 years. Now, situation 2, pending completion. That is, it is an interim arrangement. No putting the contractor on holiday, ONGC shall neither issue any tender inquiry to the defaulting contractor nor shall consider their offer in any ongoing tender. So, to take that action under 18.6 Roman 2, no prior notice is required. Notice is required only when we finally decide to put the contractor on holiday and during the inquiry. And this is, number two is a situation pending inquiry. Here it is a case, the final order has not been passed. It is pending inquiry. ONGC has made it clear that we are going ahead with an inquiry, and in that inquiry will be given everything. But pending inquiry, this order is passed. So, my lord, the situation is, my lord, situation is the contract was terminated for the fault of the contractor as he failed to mobilize. On the date of termination, this order passed in WPC 5870 was not in existence. So this, in my respectful submission, this cannot be a relevant factor or consideration to test the decision-making process and the decision which was arrived on 16/1/24. That legality or otherwise of that decision of 16/1/24 to terminate the contract has to be examined on the basis of the facts and circumstances which prevail on that day. And as if the termination is found to be valid, then as a consequence of this termination, the case covers under 18.6 Roman 2. Now the petition has, on the last date, I have placed before Lordship that the petitioner has not only accepted the NOA, he has not only declared that he will be mobilizing within 59 days. In fact, my lord, after the NOA was issued, he has written a mail expressing his intention and fixed a date for inspection of the vehicle on 28/11/2024. 28/11/2023, my lord. He writes a mail to ONGC saying that I am ready with the vehicle, kindly depute person for inspection on 28/11. And please depute someone on 29/11. Accordingly, we processed, but he did not turn up with the vehicle. And then on 1/12/2023, he writes a letter for extension of that. The fact that he has accepted the NOA and that he has written a mail for inspection has not been placed before this honorable court in the writ. So, my lord, the petitioner, what he has done, having failed to mobilize, he is taking advantage of this subsequent order. And in the process, he is questioning his own allotment, my lord, saying that the NOA was not issued, was illegal because of the interim order. And the Lordship has seen the interim order. Interim order was passed, which was clarified, and it is confined to the bids of the writ petitioner. And it is an admitted position, it has come on record that that writ petitioner Mahmood Ali had offered his bid in respect of 2 tankers. That is why, on interpreting the clarification of this honorable court, ONGC has not issued any NOA for others. And we have made it clear in our additional affidavit and in our stay vacating application that why only 6 tankers. This writ petition was pending. So, in any case, even if the writ petitioner wins that case, his bid is confined to 2 tankers. That was not allotted to him. But so far the others are concerned, my lord, there is no point on keeping all the tankers blocked, because in any case, the petitioner would not have been entitled to an allotment for all the 8 tankers. So, in such situation, my lord, our respectful submission is the cancellation was valid and it was done in accordance with the NOA or the tender notice. And since the NOA constitutes the formation of the contract, the NOA is binding between the parties. And the NOA having been terminated, the consequence which follows from such termination is also not illegal. I'll take your lordship to that part of the undertaking where he has given his undertaking that he will be submitting in the. Before that, lordship will have a look at his email. In our, my lord, page 26 is the email of the, in the IA, page 26 is the email of the writ petitioner.
You've not filed your affidavit in the writ petition.
No, my lord, we are relying on this IA because in the stay vacating application, whatever the serious contentions is, we have answered. Now, lordship may come to page 26. It is the email of the writ petitioner. Sir, with due respect, this is to inform you that the drinking water tanker is ready for deployment on your duty. So, request you to kindly arrange for inspection of the tanker on 29/11/23. We are submitting all required documents in your office tomorrow morning. Then, my lord, after 28/11, he writes a letter on 1/12, which your lordship will find at 258, page number of the 258 of the writ petition, seeking extension of time. Which was rejected by ONGC by letter dated 1/12/23 at page 261. And therein it was made clear that last paragraph, therefore you were requested to adhere with the mobilization timeline mentioned in the notification of award dated 4/10/23 and mobilize the tanker within the mobilization period as per NOM. Not done. Then on 16/1/24, it was terminated. Lordship comes to page 239. Lordship will see the undertaking given by the petitioner.
Page
239. Here your lordship will find it is an undertaking of the writ petitioner. Lordship will see, I do hereby undertake, it is the third paragraph, mobilize the offered tankers within the stipulated mobilization period of 90 days of the issue of NOA. However, we do hereby undertake that we will mobilize the tanker within 3 days of date of issue of NOA for category 1 and for category 2, 59 days. Petitioner's bid in respect of category 2 was accepted. Now, my lord, another question situation is this writ petitioner was allotted the NOA, the work order on 4/10/23 along with 4 other persons. All those persons had complied with the NOA and placed the vehicle within that pit. That is why, my lord, when the writ petition was allowed and those aggrieved persons had filed an appeal which is pending, this honorable court allowed them to continue with that. Now, had the writ petitioner mobilized the vehicle within that period, he would have been in the same footing with the other bidders who were allotted. And he would have also continued. Just because he failed to mobilize and the contract is terminated, he cannot be allowed to take advantage of a subsequent development. and that subsequent development may not be a relevant consideration for deciding as to whether the termination was good or bad on 16/1/20. Now, if the termination is valid, legal, termination of the contract is legal, then the consequence of termination will follow definitely. That, as a consequence, the ONGC has the power to initiate an inquiry, and pending inquiry not to issue any tender or inquiry or to accept its bid on any ongoing tender process. That is exactly what has happened in this case. The inquiry has not been completed, or no final order to put the petitioner on a holiday for a period of 2 years is yet to be passed. That is why, my lord, this is a case where a pre-hearing is not a requisite for taking a decision under 18.6 Roman 2. Opportunity of hearing is required only when the final order to put the contractor on holiday is required to be. That stage has not come by. No order has yet been passed. Lordship will see the bid evaluation criteria at page 180, which will give your lordship an idea on the basis how the petitioner was selected. Point 7. In case same rate is received from different bidders, ONGC will evaluate and rank the bids on the basis of following criteria for that particular type of tanker, water tankers, in the following order preference. Vintage of the offered water tanker, latest vintage will be given preference. Minimum mobilization time quoted for the offered tanker. Now, my lord, the category where the writ petitioner was selected is a new tanker. So all the bidders had given that they will be placing the new tanker. So the vintage of the tanker goes out of question. All are new tanker. So it is covered by number 2. The minimum mobilization time quoted for the offered tanker. So rate same, minimum mobilization selection criteria. This is how the petitioner turned out to be a successful bid. We have stated in our affidavit that there were same bid in respect of the new tanker of around 8 to 10 bidders. I am placing that value. If your lordship takes our IA, in paragraph 3, we have stated that the applicant state that the writ petitioner had participated for
1 minute. Yeah.
Page 5, paragraph 3. The applicant state that the writ petitioner had participated for 2 numbers of tankers against tender number so and so. The offer of the writ petitioner was accepted for 2 numbers tankers as per his bid quoted under the following category. After completion of techno-commercial evaluation of the offers received in the ONGC tender, 14 bidders, including the writ petitioner, were shortlisted for price bid opening. Accordingly, the price bids of the shortlisted bidders were opened on 26/9/23. On opening of price bids, the offer of the writ petitioner was found to be L1 along with 7 other bidders, meaning thereby that out of 14 shortlisted bidders, 8 bidders had quoted the same rate. So, my lord, 8 bidders quoted same rate and the category is new vehicle. That is why the bidder was selected on the basis of the undertaking of mobilization. The writ petitioner was awarded the NOA for hiring one number of tanker, though he had participated two number of tankers, the decision to award the contract was on account of offering the tanker under category 2 with less mobilization period as compared to other L1 bidders in terms of BEC clause 3.7. Now here we have quoted 3.7. And next paragraph, we have stated that as per the NOA dated 4/10/23, the writ petitioner was under an obligation to mobilize and place the new tanker within 59 days of issuance of NOA. Clause 3 of NOA reads as under. And that NOA, your lordship will find we have enclosed in this writ petition annexure B. Writ petition in our affidavit also, in our IA also at page 23. On the left hand side, date 14/10/23 and lordship at page 24.3, page number 24. It is written mobilization period within 59 days from the date of issuance of NOA. And in the NOA, it was very specific and clear. In case the contractor fails to mobilize the water tanker within the mobilization days, the NOA will stand automatically cancelled and ONGC will take recourse to action as per conditions of the tender. So, not only the tender permits ONGC to cancel the NOA for non-compliance of the mobilization period, it also empowers ONGC to take further follow-up action as a consequence of termination, which I have already pointed it out to your question. So, the whole case, so far ONGC is concerned, on 14/10/23, NOA was issued, 59 days of mobilization. He expressed his intention to mobilize and offered his vehicle to be inspected on 29/11. Then subsequently, he made a U-turn and failed to mobilize. So, as per the NOA and as per the tender, the termination took place, and as a consequence of termination, this order, impugn order and the challenge has been issued. The whole case of the writ petitioner is that since the earlier order has been tender, when the tender has been set aside, so this action is bad. Now the question is, if the termination is valid, because on the date of termination, the NOA was not set aside or the tender was not set aside. So it is a subsequent development. So the action of ONGC to terminate the contract has to be examined on the basis of the facts and circumstances that prevailed on that day. And since your lordship has also taken note of the interim order and the clarificatory order, the clarificatory order is very clear in respect of the tenders of the petitioner. So petitioner has, since there is only one tender, so the tenders would mean the bid. So it is the bid of the writ petitioner. And the writ petitioner has bidded for 2 vehicles. That is why out of 8 water tanker, we have not issued NOA for only 2. So for other 6 are concerned, we had issued NOA. So this NOA is a valid NOA. There is no stay order operating. Even that 4/10/23 NOA was put under challenge in that IA, which your lordship intended to have a look. And if your lordship goes to the order, passed on different days, there is no stay, nothing to indicate that those NOAs were ever stayed by this order. Okay, so if that NOA was operating, then it was obligatory on the part of the writ petitioner to comply with the conditions of the NOA, which he has failed, as a result of which the termination took place. And as a consequence of termination, this order was passed, not to issue any fresh tender or tender inquiry. However, his earlier or ongoing contract where he is given the work will not be affected. And the final order of putting the contractor on holiday for 2 years will be passed after inquiry, and in the inquiry he will get the opportunity, notice will be issued, and he will get the opportunity to defend himself. That stage has not come. It is only at the subsequent. So there is power. Everything has been done in terms of the tender and the NOA. So there is, and one thing, since the writ petitioner has not disclosed the fact that he had offered his willingness to comply with the mobilization period, and he has offered for inspection of the vehicle. This is a relevant fact which has been omitted in the writ petition. So, my lord, I'll again submit that this relevant, for not placing this relevant fact, it reflects or questions the conduct of the writ petitioner.
Suppression.
And that law, on the other day, I have placed that judgment of well, perhaps I have given your lordship on that day. 2008 12 SCC 481. 2008 12 SCC 481.
Yes.
KD Sharma. KD Sharma was the Steel Authority of India.
Yes, clip it.
Here, my lord, the Honorable Supreme Court has held that whoever submits or suppresses material fact, no relief, equitable relief can be granted. Now, this is a relevant fact. It is not that the petitioner, it is his own conduct that he had offered his vehicle to be inspected on a particular day. And then 2 days later, he files an application for extension of time. But this important aspect has not been placed on record in the writ petition. And my lord, they are submitting, they structured the case that since the period of mobilization in the tender was 90 days,
Where was that email page?
page, my lord, email is page 23. Just, no, my lord. No, I'm sorry, my lord. It is page 26, annexure C, page 26 of the IA. No, my lord, if your lordship comes to paragraph 17 at page 13 of the writ petition, the petitioner case is I'm reading, my lord. The petitioner respectfully begs to state that the entire tender process has been put on hold by operation of law in view of the order dated 14/10/23 passed in WPC number 23 587/23. But despite that, the respondent issued NOA to the successful bidder, including the writ. Since the petitioner was in dark as to the passing of the order dated so, on receiving the NOA, the petitioner deposited the security amount with the respondent as stated in para 10, herein above, and also purchased the chassis for tanker to bank finance. Surprisingly, where the entire process was on hold in terms of the order dated 4/10/23 as aforesaid, respondent issued a communication through a mail dated 16/1/24 with the subject termination of the contract. Now, my lord, what is the project? As if, my lord, nothing has happened in between. The fact that 14/10/23 order was clarified by this honorable court. 410, sorry. My lord, if your lordship takes up paragraph 17, it appears that everything was on hold. Then suddenly the termination order was issued. The facts that unfolded in between, that there is an order of 10/11/23 of this honorable court clarifying that position. The fact that on 28/11/23 he writes a mail for placing the vehicle for inspection. The fact that ONGC has accepted that and waited for that inspection, nothing has been placed, man. As if from 4/10/23, suddenly 16/1/24, the termination order is issued. Now, this paragraph shows not only there is suppression of material fact, there is suppression misleading statements also.
Let us see that para again.
Paragraph 17, page 13. That the petitioner respectfully begs to state that the entire tender process has been put on hold by operation of law in view of the order dated 4/10/23 passed in WPC number 20. But despite that, the respondents issued NOA to the successful bidders, including the writ petitioner. Since the petitioner was in dark as to the passing of the order dated 4/10/23, so on receiving the NOA, the petitioner deposited the security amount with the respondent as stated in para 10 herein above, and also purchased the chassis of the water tanker through bank finance. Then, my lord, surprisingly, while the entire process was on hold in terms of the order dated 4/10/23, no statement or no indication as to that order of clarification issued by this honorable court on 10/11/23. As aforesaid, the respondent number 4 issued communication through mail dated 16/1/24 with the subject termination of the NOA contract so against tender number. But in the letter, it was stated that the NOA has been automatically cancelled with effect from 12/12/23 as the petition has failed to mobilize the water tanker within the stipulated period of 59 days from the date of issue of the NOA. So, my lord, three things, at least two important aspects were not placed on record. The clarificatory order, which your lordship has seen in the IA dated 10/11. 10/11/23, and the intention of the writ petitioner to mobilize and place the vehicle for inspection. These two things are important. So, the petitioner having not placed all materials and in view of Teddy Sharma's judgment, which was followed by Kishore Samriti in 2013, 2 SCC page 398.
2000.
Perhaps that is not there.
Same proposition.
Same proposition. Now, here, paragraph 31, more importantly, the people who approach the court for relief on an ex parte statement are under a contract with the court that they would state the whole case fully and fairly to the court. And where the litigation has broken such faith, the discretion of the court cannot be exercised in favor of such litigant. 2013, volume 2, SCC 398. Paragraph 31. Have a lordship got it?
Yes.
Paragraph 31. Then 32.1. Courts have over the centuries frowned upon litigants who, with intent to deceive and mislead the courts, initiated proceedings without full disclosure of facts and came to the courts with unclean hands. Court have held that such litigation are neither entitled to be heard on the merits of the case nor are entitled to any relief. Number 32.2. The people who approach the court for relief on an ex parte statement are under a contract with the court that they would state the whole case fully and fairly to the court. And where the litigant has broken such faith, the discretion of the court cannot be exercised in favor of such a litigant. Number 3, 32.3. The obligation to approach the court with clean hands is an absolute obligation and has repeatedly been reiterated by this court. So, my lord, on this ground, the writ petition, no relief should be granted to the writ petition. Is one aspect. Number 2, my lord, whether the order of that court passed on 26/24, the final order, wouldn't be a relevant consideration to test the decision-making process and the decision of the authority that took place on 16/120. If not, then the decision is a valid decision. And if that decision to terminate the contract is a valid decision, then as per the conditions of the NOA or the tender, the consequence will also be valid. And the third aspect is there is no explanation as to why the writ petitioner immediately did not challenge the 16/124 order. That 16/124 order and was passed and it was communicated to them, they have not challenged it. There is no stay order. It is only when this subsequent order was passed and the consequence order of termination was issued, the petition has come before this order. So, my lord, in our respectful submission, there is no illegality in the order, and the termination being valid, the consequential order under 18.6 Roman 2 cannot be faulted.
My lord, after hearing my learned friend, the impression which I am getting is, my lord, that judgment dated 26/24 in the earlier writ petition is of no consequence. That judgment is nothing but a scrap of paper. So he is calling upon your lordships to decide the matter as on 16/1/24, the date on which the contract was terminated. This is his basic argument. And suppression. My learned friend has read para 17. Why has he not read from para 10 onwards? The writ petition contains as many as 33 paragraphs. He has read only para 17. Why has he not read page 258? He is alleging suppression of material fact. Please come to page 258. I'm dealing with the suppression aspect first, my lord. 258. I'll come date-wise, I'll show, my lord, why they are wrong. Just I'm dealing with the suppression point. Kindly see 1/12/23. With reference to the above mentioned subject, I would like to state that after receive the under reference NOA, I purchased the required new tanker chassis bearing number so and so. I even got my RTO registration number. I purchased the new vehicle with financial assistance from Canara Bank. Annexure A to 5 are vehicle documents, including the loan sanction letter. That's soon after my purchasing the new water tank, I got the information that one bidder, namely Mahmood Ali, instituted one writ application before the Honorable Guwahati High Court against your corporation, which was registered as WPC number so and so, and thereby challenged the issuance of NOA by your corporation. Even I came to know that the Honorable Court had imposed some restriction for further going ahead with the process placement of vehicle as per NOA by its initial letter date order dated so and so. Thereafter, I communicated the matter with few of the concerning officials of ONGC, who verbally advised me to wait for some weeks' time to place my vehicle. Due to the above reason, I was frightened to further go ahead to place my vehicle. Hence, delay was caused to place the order to purchase and fitting water tank. Moreover, I was I was taken seriously sick and cannot supervise the fitting of the water tank. I came to know that the above case is fixed on 14/12/23, medical annexure document. Therefore, I request you kindly to consider my matter and do not put any adverse remark or ban my firm from doing contract with your organization. For this act of kindness, I shall remain ever grateful to you. Why this letter was not read out, my lord? Why only para 17 was read? My lord, para 17 was a chronological depiction of facts. It all starts in para 10. It ends in para 33. My lord, we all know if there is a suppression of material fact, then yes, certainly a litigant is not entitled to equitable relief. There is no dispute on product proposition. My lord, kindly see the futility of the argument of the respondent. Their contention is their termination is good and this High Court order is of no consequence. Basically, he is arguing that. Has he ever referred to that order of dismissal of allowing the repetition? Because according to him, it's not required. Now I'll give the dates. 26/9/23, my lord. Kindly note. Price bid pursuant to the NIT was fixed. Now, my lord will kindly come to page number 172. I'm going chronologically, my lord. Sorry, not 172. Was to as a rate to দিব লাগে 118. Yes. Please come to page 178, my lord. Now, what is the case about? What was that earlier case about? Because lordships will have to write the judgment, therefore I must place the facts. I'm just replying to what my learned friend says. See, my lord, the bids will be evaluated based on calculated lowest monthly outgo L1 as per price quoted by the bidder in schedule of rates given in the tender of the water tanker. The monthly outgo will be calculated as under. Now kindly come to the second portion. Bidder to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.25 into diesel rate declared by IOC for Sibsagar on the technical bid opening date. That means, my lord, while evaluating the financial bid, what they will consider is 0.275 into the rate of diesel on that particular day in Sibsagar district. Now, the dispute before the single judge coordinate bench in the 5873 was, my lord, that different petrol pumps are charging different rates. The rate which according to ONGC is the rate which is being fixed by IOCL, that was not in public domain. Because in the earlier tenders, they used to give that fixed rate. So there was no problem. This time I have resorted to this, my lord, so that they can play googly. Everybody feels like bowling googly, my lord. So, my lord, this was the dispute. This price was varying from petrol pumps to petrol pump. That is why we approached the Honorable Court. That we have gone to 3-4 petrol pumps, all are quoting different price. Therefore, we have to quote the price which is prevailing in the Sibsagar. So that price, uniform price, was not available in the public domain. That is why, my lord, please come to the impugned judgment. Page 271, my lord. Please come to the last page at 275. Para 12. Now, this judgment was not even read, as if this judgment is a scrap of paper, as if this has got no relevance in this case. In view of the above reasons stated above, disqualification of the petitioner's technical bid was not proper, and as such, in view of this court, a fresh tender notice would have to be issued for Sibsagar district. Accordingly, ONGC shall issue a fresh tender notice by incorporating in the tender notice a method to enable the tenderers to get to know the standard rate of HSD for Sibsagar district for each day. Consequently, respondents are directed not to issue any notification of award to any of the bidders in respect of the NIT number insofar as it relates to Sibsagar district. Well, even if an award was issued, that is null and void. Now, my learned friend was finding very difficult to read this paragraph, because if he reads this paragraph, then the consequence ensues. According to my learned friend, this is nothing, because on 16/1/24, everything is all right. Why this order will not relate back to the NIT itself? What is this argument, my lord? This order is conclusive. No appeal has been filed. In fact, ONGC has issued a fresh tender after this. And now ONGC is opposing this case. I'm at a loss. It's a bizarre situation. Now, my lord, kindly take note of few dates. Now, 29/3/23, WPC number 587023 is filed.
Yes.
My lord, at page 267, the interim order dated 4/10/23 is passed. And operative portion is at 269, para 6. Having regard to the projections made, it is provided that till 6/10/23, the respondent IOCL authorities shall not undertake any further process in terms of the price bid opening statement dated 26/9/23. My lord, in this writ petition, the 5 party, including the present petitioner, could not have been made parties because it was filed on, my lord, 29/9/23. But we went to the learned single judge against the grievance of, my lord, non-availability of the price in the public domain. So on that day, my lord, nobody was given any LOA. So there was no occasion to make anybody a party. Now in the writ appeal, the grievance is taken that they were not made parties. Where is the scope of making parties on 29? Because on 4/10 you have issued the order. The writ petition was filed on 29/9/23. On that date, letter of award was not issued. So if letter of award was not issued, where was the scope of, my lord, coming to know? So on 4/10/23, there was a clear stay order saying, do not take any further steps pursuant to price bid opening. Despite that order, my lord, ONGC issued work order. The ONGC lawyer made a wrong statement before the court. Order yes. Now, my lord will kindly take IA 3297. At page number 34.
Page 34.
Yes, of IA. An allegation is raised by Sri so-and-so counsel for the petitioner that having regard to the interim order dated 4/10/23, which provides that till 6/10/23 IOCL authorities shall not undertake any further process in terms of the price bid opening statement dated so and so, some work orders had already been issued by the authorities. GN Sahela Lanet, Senior Counsel for the respondent in the ONG, denies this statement. Kindly see, my lord. On 10/11, this wrong statement, false statement was made before the court. Whereas on 4/10 itself, it was given. Now, my learned friend is trying to submit that on 4/10 it was issued. Without going into the determination as to whether work order is issued, we clarify our interim order dated 4/10/23 that the expression shall not undertake any further process means that if work order was not issued as on 4/10/23, same shall not be issued. If it is not issued, it will not be issued. If issued, it shall not be acted upon. So if it is issued, then please don't act it upon. That means in respect of all. We also clarify that interim order dated 4/10/23 shall be in respect of only those tenders where petitioner has participated. Now, this is sought to be explained by my learned friend by saying that Mahmood Ali participated in category 1 and 2, therefore there is a stay. No, it says only those tenders where petitioner had participated. That means in a tender, petitioner could also participate, somebody else could also participate. In a tender where petitioner permitted, that will not be given effect to. Am I clear, my lord? Now, why I'm saying so, your lordships will kindly come to yeah, yes. My lord, please take this for a moment, my lord. Page 602. Would your lordships kindly come to page 60, my lord, of IA 3297.
60.
Yes. Page 60 of IA 3297. It's an additional affidavit filed by respondent number 3. Respondent number 3,
Oh, yes.
yes. Has your lordship seen it, my lord? It is bidder's response sheet. Am I clear, my lord? On top?
Yes.
Yes. Kindly see name of the bidder, Mahmood Ali. Am I clear, my lord?
Yes.
Then kindly see the water tanker 1 with driver and 1 helper. Category 1 and 2. So he bidded for category 1 and 2. Am I clear, my lord? There are 3 categories in the tender. Now, lordships will kindly come to now, my lord will kindly come to page 74 of this same IA, my lord. Same IA. Same, my lord, document. Name Pranjal BP Gohai, the present petitioner. And he applied for category 1 and 2. Now, my learned friend has not answered one thing. If there was no stay order, if there was nothing, why that was not given to somebody else? So, my lord, Mahmood Ali also participated in 1 and 2. I also participated in 1 and 2. Therefore, stay order dated 4/10/2013 is operating in respect of 1 and 2. You cannot twist facts. Affidavit পাঠ্য কোড এই যে এভারমেন্ট আছে এই যে এইমাত্র যে আমি যে কেতিয়া গম পালো আহা বুলি 325 হ্যাঁ For a moment now, lordship will kindly take that IA 3252. How we came to know that LOA has been issued? It was filed by Mahmood Ali. Please come to page number 5. Now, my lord, these are the persons to whom apparently on 4/10/23, my lord, LOA were issued. For the first time, we came to know from this. I'm reading for the second sentence, my lord. But the counsel for the ONGC, has your lordship got it?
Page 5.
Page 5, my lord. Somewhere in the middle, but second line after Pranjal BP Guhai.
Yeah.
Yes. But the counsel for the ONGC authorities, while passing the order dated 4/10/23 by this honorable court, was not in a position to produce any such NOA, although he could have produced a copy of such NOA received from the respondent ONGC either through a WhatsApp message or by such electronic mode. The council could not produce the same because, in fact, on that particular date, no such NOA was issued by respondent ONGCL, but it can be presumed that such NOA might have been issued backdated just to deprive the legitimate claim by the applicant writ petitioner. The Malafide Act of the respondent ONGC is worth to be seen that issued only 6 NOAs as mentioned in their affidavit in opposition on 11/10/23. So for the first time, they disclosed about it on 11/10/23. Now, my lord, if the why in respect of those two it was not given? Because Mahmood Ali was L2. There was no obligation to give it to him. Mahmood Ali, according to financial standing, he was L2. In any case, he is not getting. Why you did not give? That means you understood the interim order properly. Now you cannot play hot and cold. You cannot blow hot and cold at the same time. While holding back issuance of 2 NOs to other successful bidders, respondent ONC deliberately has not issued NOs to the two successful other bidders just to make out a case before this honorable court against the petitioners. But facts remain is that while interim order was operating and writ petition was pending for adjudication, which is still pending, the respondent ONGCL issued NOS to 6 out of the 8 water tankers as per NIT dated so and so to the different bidders as stated in paragraph 17 of the affidavit in opposition, which is nothing but an act of defiance of the disobedience of the majesty of this honorable court. My learned friend is talking about suppression of material fact. Is it not a case of suo motu contempt against the ONGC officials? Lord, matter is very simple. Whatever, yes, I did not challenge the termination order that my lord, but for the judgment, my learned friend is correct. But for the judgment of the learned single judge, my learned friend is correct. If there is a termination, if it is not interfered by the court, consequence would be blacklisting. But in this adjudication process, will your lordships ignore the judgment altogether, which wipes out everything? What survives? That's why, my lord, from the day one, I'm finding at a loss to find out how can an authority under Article 12 take a stand that the judgment is of no consequence. It is a lot of consequence. It is something like, my lord, supposing initially a stay order is not given, ultimately writ petition is allowed. So will a party take a plea? So he didn't grant a stay order, we proceeded, now you cannot do anything. It is something like that.
What in short you're trying to say is, in terms of the NIT,
yes,
whatever, Mahmood Ali quoted for 1 and 2.
Category.
You also quoted for 1 and 2.
Therefore, as per the clarification order of the stay order of Honorable Justice Bujor Burua, my lord,
that category 1 and 2 was stayed.
Yes. No, even if it is given, it is stayed.
No, that's why it's stayed. Because the order says, if not issued, will not
Don't
issue.
issue. If issued, not give effect to.
Okay. In
So
short,
therefore, my lord, therefore, in such a scenario, whether I have been able to give the vehicle or not, whether I have within time I have done it or not, these are inconsequential.
immaterial.
Immaterial. And secondly, my lord, this termination is not the only clause. And now, for a moment, please come to page 1. It close to 180. For a moment, my lord, kindly come to page 180. Before that, if your lordship should kindly come to page 172, my lord. as a part of the tender B14, and let's say category 1, that means existing water tankers. Category 2, new orders, purchased one. And category 3, under agreement, which are already under agreement with the ONGC. So, since it was in respect of 1 and 2 by both Mahmood Ali as well as the petitioner, therefore it survives. Now, we will kindly come to page 180. C7, room 2 Miller. Minimum mobilization time quoted for the offered water tanker. However, in case the bidder fails to mobilize the water tanker within the quoted mobilization days, NOA shall automatically cancel. In such case, next qualified bidder, as per originally evaluated order of ranking, shall be considered for issue of LOI NOA. So why this was not done? Oh, you are reading only one part of the agreement. That you can terminate, that you are showing. But you are also supposed to do that, you are not showing to the court. So, my lord, the moment I fail, you should have to given it to somebody else. Why you did not do that? Because you know there is an order. So, partially you have complied with the order. So, so therefore, such a litigant should not talk of conduct of others. So, my lord, what clearly bears out is, here is a case, number 1, yes, it is a fact. I approach the court not against the termination, but against the order of blacklisting. But I have challenged both. In this writ petition, I have challenged both termination as well as blacklisting. And I have given the explanation why I have come late. Little bit. So therefore, my lord, to penalize me, it's not correct. Now, my lord, this argument that it can be as a consequence, it can be done, this has to be tested, my lord, because it run counters to the mandate in Eurasian Chemicals case, the first law on this point of the Supreme Court. There has to be a notice also on this count. It cannot be as a consequence, because by a contract, my lord, you cannot set it not a law declared under Article 141 by the Supreme Court. Because Eurasian Chemical is a law declared to be a law under Article 141 of the Constitution of India. So a contract agreement, a particular clause, it cannot tinker with my constitutional right. And secondly, my lord, I had deposited 68,000 of security deposit. He could have forfeited that. How he could have forfeited that, I'll show, my lord. Please come to page 122. Why this extreme step? Why these provisions are not shown? $19 million at 124. Please come to 19C. If contractor is unable to mobilize, deploy, and commence the services within the period specified in subclause A above, it may request ONGC for extension of time with unconditionally agreeing for levying of recovery of LD. Upon the receipt of such a request, ONGC may, at its discretion, extend the period of mobilization and shall recover from the contractor as an ascertained and agreed liquidated damage for the delayed part, a sum equivalent to 0.5% of the annual contract value for each week of delay, or part thereof, subject to maximum of 10% of the annual contract value. So, my lord, the moment I wrote that letter, then they should have invoked this clause. Then this question of termination would not have come. This is where the arbitrariness is kept in. My lord, termination is not the only, a consequence provided in the agreement. First, they must explore all this. Only when, my lord, this will not yield the desired result, then they can go for termination. So what is the explanation we have stated in our writ petition? So, my lord, ideally they should have done this. Now, on top of this, subsequently there is a judgment whereby the entire tender process itself has been interfered with. Now, can we say that the judgment will also survive and this order will also survive because it is prior to the judgment. I was giving that example, my lord, that supposing there is a not stay order is not given, eventually writ petition is allowed. And in the meantime, because there was no stay order, other side has done so many things. Does it mean, my lord, the court, upholds the action which is taken in the interregnum? It defies logic, my lord. Therefore, my lord, there is absolutely nothing wrong in my approach. My lord, these are all, ONGC is a mighty organization, my lord. I am a small contractor. Where is my bargaining power? So, end of the day, my lord, lordships will protect my right under Article 14. That's why in Ajay Hasia it was said, whenever there is arbitrariness in state action, Article 14 springs into action. This is an appropriate case. So, my lord, my reply, my rejoinder argument is very simple, my lord. The case projected by the ONGC that everything happened prior to the judgment, therefore judgment will be of no consequence, is my humble submission, is not correct. In fact, in my humble submission, the judgment is the crucial factor in this case. It will take care of everything. Whatever lapse was there, whatever shortcomings were there, everything is taken note of. Everything has merged into that. So, my lord, if judgment is good, if judgment is to be given a meaning, then the termination is also bad. And the consequential blacklisting is also bad. And most importantly, my lord, ONGC has accepted the judgment. They have issued subsequent NIT.
Let us see that operative part.
Of the judgment, my lord. Yes.
275.
275, my lord. Para 12. My lord will kindly allow me to read paragraph 11 also, because that was the basic controversy. At page 274. To ascertain whether IOCL declared their HS as the rate for Sibsagar district in public opinion on their official website, the IOCL had been directed to submit a report with regard to the same. As can be seen from the submission made by Sri M.K. Chaudhary, Lanet Senior Counsel for the IOCL, and the affidavit submitted by them, the stand of IOCL was that standard rate of HSD in Sibsagar district could be ascertained if one went into the Indian Oil One mobile app for retail outlets for Sibsagar district. This court then requested all councils to use their mobile to find out the standard rate for HSD for Sibsagar district by using the Indian Oil mobile app. The mobile app of Mr. P. Bharadwaj, who was a junior to Mr. M.K. Chaudhary, my lord, had been used, and it was found that there were variations in the rates of HSD for various retail outlets in Sibsagar, which should make the clause C.2 in the NIT unworkable. So, my lord, it goes to the genesis. It goes to the root of the matter. The very tender process, the very condition in the tender is bad. Where is the question of any right accruing to anybody based on that tender? In view of the above reasons, disqualification of the petitioner's technical bid was not proper. That means Mahmood Ali's rejection was not proper. As such, in view of this court, a fresh tender notice would have to be issued for Sibsagar district. Accordingly, the ONGC shall issue a fresh tender notice by incorporating in the tender notice a method to enable the tenderers to get to know the standard rate of HSD for Sibsagar district for each day. Consequently, respondents are directed not to issue any notification of award to any bidders in respect of NIT dated so and so insofar as it relates to Sibsagar district.
So your NOA also stands
Everything,
invalid.
everything, including those 5 who are before the writ appellate court. Now we will appear before the writ appellate court, we will make our submissions, my lord. Now there the argument made, as I have understood, that we are not made parties. As I told your lordships, 26/9 was the date when price bid was open, and 29th we approached. On that day, we need to know that on 4/10 they will issue the order. Therefore, the question of making them parties does not arise. And they were aware of the proceeding. They should have come and, my lord, implemented themselves. So, my lord, if the tender itself goes, then whatever actions taken pursuant to the tender also goes. And my lord, ONGC has not appealed against this order. They have accepted this judgment. That's why they have issued a fresh NIT.
So
Huh?
according to you,
Yes.
in view of this judgment, the ONGC is supposed to float a fresh tender.
Yes.
Therefore, any action done in the earlier
Yes.
NIT
Huh.
stands all wiped out.
Yes. Subject to, my lord, further orders to be passed by the writ appellate court in respect those 5%. Because our client has not gone on writ appeal. So, qua us, there is no stay order.
So, since NO is not there, then the issue of termination does not arise.
Right? If
And-
termination doesn't arise, holiday list also does not arise. Blacklisting also does not arise. So, lordship need not go to these aspects. Though my learned friend would say that this is not relevant, but my humble understanding is this is the crucial factor.
Okay.
That is my humble submission.
Well, just two clarifications, my lord. First, in respect of that submission, that under clause 19 at page 124, ONGC could have imposed liquidated damage. My lord will see that at page 124, clause 19, the question of imposition of liquidated damage comes only when the contractor in his application seeking extension, you unconditionally agrees for levy of and recovery of LD. Now, 19C, if the contractor is unable to mobilize, deploy and commence service within the period of specified in subclause A above, it may request ONGC for extension of time with unconditionally agreed for levy and recovery of LD. Now, if your lordship takes up their application for extension, there is no unconditional application for imposition of LD. So that argument that it could have been, LD could have been imposed, well, cannot stand, my lord.
Okay, thank you very much.
Another aspect, my lord, if your lordship takes up my IA, lordship will find that paragraph 7, we have given the list of the persons who are issued NOA on 410.
Lordship, I have a matter in another court. I may be correct. Deeply.
At page 9 of our IA, at paragraph 7, we have given a list of the bidders who were issued NOA on 410. Lordship may have a look at that for a time being.
IA.
Page 9, paragraph 7.
Yes.
In that list, lordship will find Ali Brothers, 2 tankers under category 2, new tanker, all under new tankers with the mobilization period. Now, if the argument of the writ petitioner that on 4/10/23 there was a blanket stay, which according to the clarificatory order, since Mahmood Ali participated in new tankers also, so there is a blanket stay, then these persons' allotment is also bad. If that is bad, then how the writ appellate court permitted them to continue? If your lordship takes up that order for the time being,
Where is that order? What order was that?
lordship may come to page 38 of the IA. I'm reading the entire order, man. The matters come up for consideration of the instant interlocutory application so and so, so and so. IA so and so is filed by the applicants with a prayer to condone the delay in filing the connected writ appeals, whereas IA is filed by the applicant seeking leave to file appeal challenging the order. Now, it is noticed that WPC so and so was filed by the writ petitioner, respondent number 5, herein challenge the condition so and so of the tender. The learned single judge on 4/10/23, having heard the learned counsel for the parties, has ordered for listing the case on 4/10/23 and has further ordered that till 4/10/23, the respondent IOCL authority shall not undertake any further process in terms of the price bid opening statement dated so and so. It appears that on the very day, So on 4/10/23, respondent ONGC has issued NOA to 5 bidders, including the applicant. The respondent writ petitioner, number 5, writ petitioner filed IA being so and so 3252 before the writ court with a prayer to issue direction for cancellation of the NOA issued by the respondent. Now, there is no cancellation till date. It is also to be noticed in the interlocutory application as well as the pending writ petitions that applicants were not impleaded as party respondents, and the situation remained the same till the aforesaid so and so writ petition was decided. Now, the last part, my lord. The fact remains that the NOA award were issued in favor of the applicants on 4/10/23 pursuant to the tender notice issued to the respondent by the respondent ONGC. The respondent 5 writ petition was aware of the said fact and had also brought the said fact to the notice of the writ court by moving an interlocutory application. However, he had not made the application as party respondents in the writ petition. So, this honorable court division bench permitted those persons to continue, my lord. In the facts and circumstances, we deem it appropriate to direct the respondent authorities not to discontinue the NOAs of award issued in respect of the applicant. Now, my lord, what I am trying to point out that had the present writ petitioner continued with the NOA, he would also be in the same footing and permitted to carry on with the contract. The division bench, my lord, honorable division bench has also considered that NOA and the 410 order. There is no absolute ban in respect of the categories. It is only in respect of the bids of the writ petitioner, Mahmood Ali.
See the last para of page 40.
Yes, in the facts and circumstances noted above, we deem it appropriate to direct the respondent authorities not to discontinue the NOAs issued in respect of the in favor of the applicants. Applicants means the persons who have moved the writ appeal. And these applicants are the same persons who were allotted NOA along with the present writ petition. Now, since they mobilized within the period and they continued with the work, their contract survived. And since the writ petitioner failed, so his contract was terminated.
Continue reading.
However, the respondent agencies are free to proceed further in pursuance of the fresh notice dated so and so in respect of the other services except the service already being rendered by the applicant. So, my lord, why this order? So far, this out of 5, 4 continued, so they will continue. Since NOA in respect of the present writ petition has been terminated, so there has to be a retendering. My lord, had the present writ petitioner continued along with the others, this present writ petitioner would have been in the same footing. Just because the situation has changed in view of the termination of the NOA.
No, the issue is this Mahmood Ali's case.
My lord.
Where he's challenged the bid opening process.
My lord.
In that, there was a stay order with regard to category 1 and 2.
That is not what the clarificatory order says. If that is in respect of 1 and 2, the persons who had been allotted and who are still continuing pursuant to the order of this division bench.
No, that's fine. Category 1 and 2, that was state. And in the clarificatory order also, it says that you will not proceed in so far as where the petitioner has participated in the categories.
My lord. Take my lord after the my lord.
1 minute.
Please, I'm not done.
I'll just. Then after that, the final order was passed.
My lord, here the category is nowhere mentioned in the clarificatory order.
Let us see page.
Category order, if your lordship will see, examine the order, interim clarificatory order at page 30. Page 34.
34, is it?
Yes.
Huh.
We clarify that the interim order dated 4/10/23 shall be in respect of only those tenders where the petitioner has participated. So if
So he participated in category 1 and 2.
my lord, in that case, then if the original order is not to act upon any NOA, if issued, it applies to all, my lord. Where is the requirement of clarifying that? My lord, if you will read the entire order, without going into a determination as to whether a work order is issued, we clarify our interim order that the expression shall not undertake any further process means that if the work order was not issued as on that 4/10/20, the same shall not be issued, and if issued shall not be acted upon. Now, if up to this much is fine, then where is the requirement of clarifying? This clarification that if issued, don't act upon, if not issued, then don't issue. Now, by clarifying this honorable court has expressed that it is in respect of the bids where the petitioner Mahmood Ali has submitted this bid. Now, if there are three categories, Mahmood Ali has participated in 2 categories, then meaning thereby if all those categories are no or work order should be issued, then it is a blanket stay, then there is no requirement of clarification because 4/10, if not issued, don't issue. If issued, because all have participated. If issued, don't act upon, and if not issued, don't issue. To that extent, it is fine. By clarifying it, the honorable court expressed it that in respect of the bids of the writ petitioner. Since writ petitioner has bidded for 2 tankers, my lord, why am this? There is a logic. This honorable court felt that there should not be a blanket stay. That is why this clarification is given. If
So okay, then if the interim order pertains only to those tenders where the petitioner has participated.
tenders, my lord, there was a one tender. It is bids. Tender is one bids. So the petitioner, the writ petitioner Mahmood Ali has bidded for 2 tankers.
That's why. 2 category.
2 category.
One new tanker
and old tanker.
One old tanker. Correct. So that stays for both this category.
Now, if that stays for those 2 categories, then it is a blanket stay. Then there is no question of clarifying, my lord.
No. If you read above, now there was an allegation made by the council in that writ petition, Mahmood Ali's council, that you have issued work orders.
My lord.
Second para says no, that is not correct.
So that is why this honorable court.
That's why this court had to pass this order.
Yes, it says that if not issued, don't issue it, and if issued, don't act upon it. Now, by this clarification, because you see, because my lord, the question is when there is a requirement of 8 tankers, Mahmood Ali has bidded for 2 tankers. There is a requirement of tankers in ONGC. Instead of putting the entire process on hold, this honorable court, by this clarificatory order, permitted ONGC to go ahead with other except the 2 tankers where Mahmood Ali has participated. Now, if that is the reason, that is why, my lord.
So Mahmood Ali, okay, let us go according to what you say.
My lord.
So Mahmood Ali participated, let us say, for 2 tankers.
2 tankers.
One new, one old.
One. So
petitioner in this writ petition also participated in for 2 tankers.
And the ones who have been allotted, they have also participated in new as well as old, because your lordship will see it is the at paragraph 7. I have taken your lordship to that part.
So
it says all new tanker.
All of them participated for
2 categories.
2 categories.
Old and new.
Tankers. 2 tankers. Old and new. All right. So now Mahmood Ali was not happy with the price opening bid.
No.
Correct. So he went to court. He came to court.
No.
Challenging the price opening bid. Now, price opening bid would include all the tenders.
Malad.
Correct.
Malad.
Because L1 was present petitioner.
Yes. Mahmood Ali was not L1.
He
I
was
do not
not,
know. Mahmood Ali
Yes,
was not
yes.
L1.
not
Mahmood Ali was not L1.
No, that's why petitioner was L1 here,
Along with
with,
some 7 other bidders.
but then since he gave that 59 days,
My lord.
59 days mobilization period, he was selected. That's according to you, correct? And as per the terms of the tender.
No.
Now the issue is, now the whole tender notice is gone.
When?
By the final order.
When? After the termination was given effect to.
Whatever it is, the whole tender notice is gone. All NOA stands gone. Of course, again, there's a complication coming up. That's why I'm trying to see the connection. Now, again, before the division bench, they have said, okay, you let these 5 or 6 of them continue. Four of them continue.
Continue.
Five, my lord.
No. 4.
5, my lord. This is the new tender, my lord.
Then
Have
5.
my lord.
No, please.
There was a
No.
8 numbers.
There were
my lord. 8 tankers, my lord. As per the earlier. tender.
4. Why I am
This is,
submitting, my lord?
this is the tender notice, my lord. 16-1.
1 minute.
Originally, there were 8 tankers. 6 tankers were allotted. 5 bidders were given. 1 bidder got 2 tankers, new tankers, and others 1. So initially, this NOA of 410 was in respect of 5 bidders, but for 6 tankers. Now, out of 5 bidders, this writ petitioner was one of them. His contract has been terminated. So remains 4. And the division bench allowed these 4 4 contractors to continue with the NOA.
This is what this court is trying to say, is that would not the decision of the division bench have a bearing in this matter?
Definitely. Definitely it will have a bearing. Now, if for reasons division bench decides that the termination was bad, a possibility, I'm not saying right now, that the order 26/6/26/23, it was passed without hearing, and division bench may uphold this order, division bench may hold that this order is not good. Both are possibilities, my lord. So that is something we do not know as of now. But the fact remains, the division bench permitted those 4 bidders
to continue.
Now, the writ petitioner, present writ petitioner, had he been in a position to continue, because if he had complied with the his obligation, then he would have been in the same footing. Irrespective of what happened in the final writ petition, he would have been in that same position along with Ali brothers and all, who were allowed to continue by the division bench. Now, it is a case, that is why I am saying the writ petitioner is questioning his own allotment, my lord. The same.
No, what the writ petitioner is saying is, there was a stay order.
Now we have to examine whether the stay order was a blanket stay order or a stay order in respect of only 2 tankers.
And the final order had set aside the whole NIT.
My lord.
Correct.
My lord.
Now, therefore, the question of NOA to the petitioner does not arise.
But before that, the NOA was terminated. That is why I am submitting whether the termination of the NOA, because your lordship is examining the decision and the decision-making process of the authority under 226. Now, on the day on which the NOA was terminated, was this order in existence? Definitely not. So, the legality or otherwise of the termination order can be, whether it can be tested on this order.
Let us put it some other way around.
Well,
supposing the NOA was not terminated,
well,
he had mobilized on within 59 days.
Well,
in terms of the final order passed by the court, what would happen?
then the question would have been whether again he would have been along with Ali brothers and all. He would have gone in writ appeal questioning that the single bench order, saying that this order was terminating the order of terminating the NIT or the NOA in our absence, when it was known to all that I was the selected and I was mobilized, I was continuing with the contract. So the decision to terminate the tender and the NOA in my absence without hearing me, then the same question would have been raised in the division bench. Pranjal, the present petitioner, would have been in the footing of the other persons and he would have joined the other persons in the appeal. But now what happens, since he has failed and he cannot continue, the termination has taken effect, he is taking a reverse action. He is taking the plea of side of Mahmood Ali. In fact, my lord, the Mahmood Ali had questioned his NOA. And who represented Mahmood Ali? Is it not a conflict of interest, my lord? On one side, I am questioning Mahmood Ali, and Mahmood Ali as Mahmood Ali, I am questioning the writ petitioner's NOA. And then in the second round, as the writ petitioner, I am saying Mahmood Ali is right.
Where's the writ petition? That 5870.
In that writ petition, my lord,
Let us see.
there is a conflict of interest here, my lord. As Mahmood Ali, I am saying Pranjal BP Guhai's BP Bor Guhai's allotment, the present writ petition. As Mahmood Ali, I am saying that Pranjal BP Guhai's writ petitioner's allotment of NOA is bad. And the writ petitioner here says that yes, my allotment is bad. And another aspect, my lord, I have referred to paragraph 17 and the senior counsel has pointed out his application for grant of extension of time. But where is the pleading in the writ petition to show that the petitioner has asked for inspection of the vehicle? Even in that page 238 application, annexure 9, my lord, even in that also, the writ petitioner has not, even in his application at page 258, the writ petitioner has not stated that he has offered himself for examination of the vehicle, mobilization of the vehicle.
That part I've taken.
So, my lord, this aspect, even if I have referred paragraph 17, but from anywhere in the writ petition, let there be any projection from the writ petitioner that this aspect was brought into the notice of this honorable. That is why I am submitting, my lord. It is a case where the other similarly placed persons along with the writ petitioner are allowed to continue by the division bench in terms of an interim. If the argument of the writ petitioner that there was a blanket ban and that allotment is bad, then the division bench would not have allowed. The honorable division bench has categorically held that there is an order of NOA issued to those persons and this was brought to the notice of the court seeking cancellation of that order. However, they were not made party. Right or wrong, some right has accrued. So, if the writ petition, so that will be decided by the division bench. Is a different question. I am not on that. I am saying my submission is that 41023 order, it was not a blanket stay from a reading of the clarificatory law. The clarificatory order says that otherwise, my lord, it is a meaningless order. Then nobody would have continued with the NOA. Had it been a blanket order, then why the IA had to be filed seeking a declaration for clarification, for setting aside of that 41023 order. So, my lord, lordship will examine whether in view of this clarification, because if this clarification, if the meaning, what has been sought to be projected is accepted, then the clarification is nothing but a blanket stay. If it is a blanket stay, this honorable court, after pointing out that if not issued, shall not be issued, and if issued, shall not be acted upon.
Okay.
This further clarification gives an indication of the mind of this honorable court that it is in respect of the two tankers where the Mahmood Ali petitioner had submitted his bid. Because if Mahmood Ali wins, then these two tankers can be given to him. If he loses, then it will be given to other person.
No, but in that particular writ petition filed by Mahmood Ali, the issue was with regard to the HST
Yes.
rates in Sibsagar districts.
My lord, Mahmood Ali submitted his bid, and if your lordship takes up the final order, the NOA is not for Sibsagar district, and this honorable court directed for a fresh NOA in Sibsagar district. NOA was not district wise. NOA was not district wise. The direction is set aside the NOA and a fresh NOA for Sibsagar district.
For particular tender, my lord.
So if that original tender is not only for Sibsagar, this is the ONGC Assam asset. Entire area is governed. The tender NIT was not in respect of Sibsagar district. Oh, whatever it is, my lord. Ultimately, lordship will examine whether.
But whatever it is, you have accepted the judgment. You have not gone on appeal.
No, that is a fact. ONGC has not gone on appeal.
Hmm.
But the other person has gone on appeal.
No,
Now,
other four.
Other four. This writ petitioner, if we visualize it from this aspect, the writ petitioner, for some reasons, had continued with the NOA. He had mobilized. Then what would have been his position? His position would have been similar to the other person's. And in that scenario, he would have joined the other person in the appeal, contending that the adverse order was passed without hearing me. Since his NOA was cancelled, he is taking advantage of this peculiar situation. He is taking advantage of this peculiar situation. Now, my lord, if he was aggrieved, then what is the reason why he did not challenge the 16124 order? It calls for an explanation, my lord. 16124 order was not challenged immediately. Normally, what happens, my lord? If someone's contract is terminated, he immediately rushes up to the court saying that it was terminated without any valid reason, whatever reasons, and it is challenged and interim orders are prayed for. He allowed that to happen. He waited. And when things changed, he is now trying to take advantage of a subsequent incident or happenings. So
yes, DK, do you have anything, or you want your senior to?
Yes, my only submission, my lord, senior counsel already submit, my lord, our grievance, my lord. My lord, tender, my lord, originally 8 numbers of water tanker, my lord. And my lord, out of 8, my lord, 5 bidders already, my lord, 6 numbers of tender already issued NOA, my lord. My lord, my learned senior friend, my lord, that my lord, only 4 tenders, my lord. Now,
Six tankers.
6 tenders already, including the present petition also, my lord.
Hmm.
That number 1 is one of the contractor 2, and others, my lord, 1. Total, my lord, 6. My lord, as per the, my lord, the single base, learned single judge order, my lord, on 26/2020, final order, my lord. Then, my lord, fresh tender has been issued on 19/8/2020.
Where is that tender?
My lord, already, my lord, senior, my lord, subsequent, my lord, what happened? Division bench order, my lord.
Division bench order, I've seen that.
Yes,
you
that,
have
my lord,
issued a fresh tender.
Yes, 19/8/2024, my lord, a fresh tender issued. And subsequent, after this division bench order, my lord, this is the, my lord, fresh tender on 16/1/2020 against, my lord, 3 tenders, 3 water tankers, my lord.
maybe
that means, my lord,
Maybe
My lord, kindly say,
earlier it
my
was
senior
8.
friend submit my lord.
My
two
lord,
tankers, two
earlier,
tankers, my
no,
lord.
no, no.
One
not
minute,
two
1 minute.
tankers.
Chakravarti, 1 minute. I'll hear you. I'll give you time. Don't worry. Otherwise, if two of you start
Yes,
talking,
sir.
it will make no sense.
Sorry.
Yeah.
My lord, after issuing the my lord impugn order, my lord,
After the division bench passed the
yes,
order,
that is my lord 19/8/2024, the press tender has been issued, my against
where
eight-
it is shown
yes,
that
page 40, my lord.
mm,
Page 40, that is a press tender notice dated 19/8/2024 in respect of the other services, except the services already being rendered by the applicant. So accordingly, 19/8/2024, after the court order, my lord, on 26/2024, 8 tankers NIT has been issued, my lord. After this order, my lord, ONGC, my lord, modified, my lord, and 16/1/2025 against, my lord, 3 tankers. That means, my lord, 8 originally 8 numbers, 5 already, my lord, is already, my lord, they got interim order, my lord, this not to discontinue, my lord, still pending, my lord, and 3 tented. Total, my lord, 8 numbers, my lord. That is my humble submission. Other, my lord,
Exactly.
senior council already submit.
My lord, that is how, that is exactly, I was also telling. Earlier
No,
8,
you 4 tender.
earlier 8 tankers. I'm making it simple, my lord. Earlier 8 tankers.
one got an extra.
Earlier 8 tankers, 5 bidders were given 6 tankers. So 4 person got 1 tanker, 1 person got 2 tankers. Petitioner Pranjal got 1 tanker. So Mahmood Ali, in respect of Mahmood Ali, 2 tankers were there. They have retendered it. Since they have terminated the contract of Pranjal, 1 tanker. So out of 8, they are now going ahead for 3 tankers. Initially, for all tankers, 8 tankers, in view of the interim order, they have gone for 3 tankers.
Let us see the new
Yes.
NIT.
3 tankers.
I got your point.
So the
Out of the 4 applicants in
Yes.
the division bench,
my lord,
3 of them they got one tanker each. Correct.
1 got 2
One,
tankers.
one got 2.
And
So,
petitioner had got 1.
so that means 5.
5.
All right.
5.
And petitioner got 1,
One.
and then this Mahmood
Mahmood
Ali.
Ali, since he applied for 2, that 2 tankers were not earlier allotted to anyone.
Mahmood Ali, how it was possible, my lord? Mahmood Ali, that time, my lord, Mahmood Ali challenged, my lord, price bid, as already, my lord, senior council submit.
Mahmood
He was
Ali-
not, my lord, L1, my lord. My lord, kindly see the, my lord, the original writ petition 5870 for the timing. For a moment, my lord, kindly see, my lord.
1 minute. 16/1/2025.
Lordship.
These are the latest one.
Yes, my lord, after the order passed by the, my lord, division bench, my lord. Originally, it was 19/8, my lord, then it was modified. My lord. Other terms and conditions are same.
Okay, other terms and conditions,
Yes.
all the same.
Yes,
All the
all-
same. So, my lord, Mahmood Ali applied for 2 tankers, which were not allotted to anyone. Out of originally 8, 2 tankers were not allotted, 6 were allotted, including a writ petitioner. Since writ petitioner has allotment has been cancelled, so 1 tanker comes. And Mahmood Ali, in that respect, 2 tankers. So these 3 tankers, which have now
You bidded for how many tankers?
2 tankers, my lord.
he
Present-
bidded for 2 tankers.
Present petitioner also 2 tankers, my lord. Mahmood Ali also 2 tankers. One old, my lord, and
new.
one new, my lord.
And the persons who had been given, also I have shown your lordship from paragraph 7, new tankers.
No, my lord, all, not all, my lord. This is, my lord, kindly see page 9, paragraph 7, my lord. Only one contractor, my lord, two tankers, my lord.
Oh,
No. Where page?
Page 9, my lord.
page 9 of the IA.
Of your eye.
Lordship will
Ali
see
Brothers,
Ali
200
Brothers under
category
2
2.
category new tankers. So Ali Brother has been given 2 tankers
All under new tankers.
under new
Yes,
tankers.
yes.
So if the argument of the writ petitioner is to be accepted that there is, since Mahmood Ali has applied for new as well as on old, so there is a blanket stay, then this allotment would have been held to be bad by the division bench also, my lord. So all are new tankers. All are new tankers, including the present petitioner. Except the present petitioner, others had mobilized.
Let us see that NIT again.
My lord, may come to page 172. B 1.7, number of tankers offered. The bidder should offer for hire a minimum of one number of tankers. What is relevant is the number of tankers and the
1 minute. This is for Assam asset.
Assam asset. So, my lord, Assam asset is not confined to Shivsagar. Assam asset, Jorhat, everything is Assam asset, entire Assam asset. So, the tender, it was not confined to particular Shivsagar district. The direction was to file a fresh tender for Shivsagar district only. Then how, my lord, it is not confined to Shivsagar district.
My lord, clause, my lord, which was agreed by the my lord, that earlier petitioner, my lord, that was, my lord, kindly see page 200, my lord,
Of
read petition, my lord, present. 200, my lord, C.2, my lord.
1 minute.
Already senior counsel already, my lord, submit, my lord, in the figure. That last one, my lord, bidder to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.275 into diesel rates declared by IOC for Shivasagar as on TBO date, my lord. That means a technical bid opening date, my lord. So, my lord, Shivasagar district only.
Tender bit opening.
Yes, my lord. Technical bid opening date.
So this
Yes,
Shivsagar.
my lord.
Rate, what it was proposed, that it is the rate which was prevailing at Shivsagar. The tender is not for Shivsagar. So,
No, that's why. Tender is Assam asset.
Assam asset.
But the rates to be quoted
For Shivsagar
was
district.
in terms of the rates prevailing in Shivsagar district. No,
But the direction is, if your lordship takes up the direction,
let us see 1 second, the single bench. Yeah.
Page 175, my lord. 275, my lord. It starts from 271.
in paragraph 12, in view of the disqualification of the petitioner's bid was not proper as such, in the view of this code, a fresh tender notice would have to be issued for the Shivsagar district. Meaning thereby, it is only the requirement of a tender is for Shivsagar district only, not for other areas of Assam. Consequently, the respondents are directed not to issue any notification, however, to any. My lord, if that NOA of 410 was a blanket stay, then, my lord, this honorable court would have clarified in the final order also that NOA dated 410/23 stands set aside. So, there was a specific challenge to the NOA dated 410/23. This NOA dated 410/23 was not set aside. And accordingly, the ONGC shall issue fresh tender incorporating in the tender and method of so and so, so and so, so and so for this for Shivsagar district. So, the direction is to issue a fresh tender for Shivsagar district, not for the entire Assam asset. That is why, my lord, whatever I am submitting, I am saying.
Now, how can you have a tender for Shivsagar district?
That is not there, my lord. It was for Assam asset. The direction of this, if we are to follow this direction of this honorable court, then it cannot be for Shivsagar district only.
So what revised NID did you survey?
We have NIT for Assam asset. Earlier also it was Assam asset.
And with regard to the tender rate?
Tender rate, that NIT I do not have, my lord, that I do not have. But maybe the tender rate, in the tender rate of,
For quotation of rates.
for quotation of rate, the fuel price may be taken up for consideration of Shipsagar only. That is one aspect. But NIT for Shipsagar means tank only, that there is no specific indication in the NIT that the tankers will be required for Shipsagar district only. NIT is for tankers, and in that tankers rate is to be given. So the rate of fuel at Shipsagar district will be taken as the base value for accepting the bid. But the tankers may be from anywhere. It can be Assam asset means entire Assam. Not for the, that is.
No, you're correct. That
So, my lord, whatever I am submitting, I am submitting, my lord.
Earlier affidavit, my lord. When you see, my lord, in the when see affidavit file, my lord, they said, my lord, that tanker, my lord, are applicable for my lord Chittorgarh district. In the affidavit.
Which affidavit?
My lord, in read petition number 587.
That I do not have.
My lord, maybe my lord, my
I was not there in that read petition.
I know.
So, my lord,
Let us have a look at the the disposed matter, isn't it? That earlier read petition.
Yes.
You have a copy?
I don't have that.
Uh,
What I am submitting, my
no,
lord.
Chakrabarti, what I'm thinking, because there's some complicacies here. One, clear factory order, final order.
Then
Then
termination order before passing of the final order.
Plus
Then
the
a division bench order
division bench
permitting
four
everyone.
of them to proceed.
So, and
why not?
even, my lord, in the final order, lordship will visualize one thing. There was a specific challenge, even by way of an IA, that there is a specific challenge to the NOA of 410/23. But the final order that this honorable did not set aside the NOAs dated 410/23.
Or lordship may fix, my lord, after disposal of the my lord writ appeal, my lord, because my lord writ appeal, my lord, it was not decided till the my lord,
Then, my lord, the entire exercise of arguing for several days, right or wrong.
My lord, my humble submission, my lord, because my lord, if my lord, the division bench, my lord, set aside, my lord,
When is the
my lord,
when is the matter in the
matter
division
was
bench coming
yesterday,
up?
my lord, matter was listed, my lord. After 2 weeks, my lord, date was not fixed, my lord. After 2 weeks, my lord.
It was listed on several.
The
The problem is, my lord, in that writ appeal,
Because, my
someone else is appearing. So
you are not appearing.
No, in that case, senior counsel is engaged. The present advocate general is appearing.
Because
on the
once,
bench.
my lord, the earlier tender is set aside, my lord, then, my lord, this also affect, my lord. As per the, my lord,
No, if the division bench,
my humble submission, my lord.
if the honorable division bench allows the appeal, definitely this present order will have to go, and the matter will come back, or may not do that also. Now the question is, when the termination order was passed, this order was not there in existence. So I'm once again at the cost of repetition submitting before lordship is whether the termination can be tested on subsequent facts. So, my lord, this matter has been heard at length, and I have clarified this. If the interim order is supposed to mean there is a blanket stay, then these persons also cannot continue because there is a blanket stay, which is shown to be different from the order passed by the division bench, my lord.
See, Chakrabarti, this is what I'm also thinking. Division bench judgment would have a bearing here. Why not we wait for some 2 weeks or 3 weeks and let it come
My
up?
lord, this division bench, the matter is coming up, it has come up several times. And I have filed this IA and this IA for vacating of the interim order. And the IA has been prepared in a manner that we can rely on the IA to go for a final disposal.
Correct.
So we have taken note of all the aspects. This IA can be considered as a counter to the writ. So after carrying out an exercise of a full-length hearing for 2 days, my lord, in my respectful submission to wait for the outcome, In that case, my lord, we'll wait for the outcome. Let the interim order go. Lordship will decide the interim by I.
That would have a very okay, we'll list this matter again on Tuesday. Let me go
My
through
lord,
this.
Tuesday I'll not be available at Guwahati.
In that case, 8. No, 8, my lord. Senior counsel already, my lord. Junior, my lord, already instructing, my lord. Please, there, my lord, some difficulties, my lord. My lord, can it be, my lord, 15 or 16?
That's fine. 15 is the hearing day?
Yes, my lord, Thursday, my lord.
Yeah. 13th?
16, my lord.
I think many cases I fixed
Yes.
13th. Correct.
Then, my lord, after
So-
28, my lord.
No, we'll have it on 15th. Let us not
15 or 16, my lord.
let us not delay the matter.
It is already, this
Lordship.
I was filed last year, my lord.
Hmm.
And it, for this season or that, and your lordship is aware, the apex court is also saying when there is an IA for vacating of an interim order, that IA should be taken up for consideration.
No,
and
but then we have already got
we have already, and your lordship has expressed for a final disposal,
Yes.
and in pursuant to that order, we have carried out that exercise, and lordship
only problem that
has
is
given a patient's hearing.
only problem that is coming up today
Hmm.
is the final order of this court in that writ petition and the interim order of the division bench.
Hmm.
This is what is bothering me a lot. This is what is bothering me a lot.
It was my
So, my lord, what
conclusion,
I
my lord.
submit, my lord, lordship will take a call. At the end of the day, the division bench order or the other thing, these are the matters of record, which we can point out, but there is no chance of any change in that order. Whatever the division bench has ordered, whatever the single bench has ordered, whatever it is only the question of interpretation and to decide. So instead of keeping the matter pending,
My lord, once
my
more-
prayer before your lordship is to finally decide this were that day or order, whatever order your lordship feels appropriate will be considered, my lord.
If, my lord, division bench, my lord, set aside the learned single bench order, my lord, then, my lord, it is different, my lord. If, my lord, allowed, then, my lord, the tender also, my lord, go, my lord. Then, my lord, tender was the death tender, my lord. My lord, kindly see the new tender, my lord, on 16-1. That the tender is, number is different, my lord.
So new tender is in respect of 3 tankers.
3 water tankers.
3 water tankers.
And tender number is
where
different, my lord.
it was not allotted because
Earlier,
of
my lord,
the
it was,
writ
my
petition of Mahmood Ali, and one this present writ petition which has been cancelled.
It was, my lord, earlier R16, R2.
Definitely, my lord, definitely. When a fresh tender is issued, always there will be a new number. It can't be said that the earlier tender number will continue. It's a fresh tender, and that is why earlier it was 8 tenders, now it has come up to 3 tenders. So, my lord, my humble submission before lordship is to close this matter, and your lordship, whatever decision falls from your lordship.
Will you be available on? Oh no, you're not available
On
on
6th, on 6th, my lord, I'll not be in station.
8.
8, my lord, senior counsel, my lord, already give me some date, my lord. 15 or 16 is possible, my lord.
Because, my lord,
Okay.
16, my lord.
lordship will conclude the hearing, and if your lordship.
No, we'll fix it on 15. Under there, I'll take a final decision. But Mr. Ken Chowdhury and Senior Assistant by Mr. M. Hinke, and counsel for the petitioner, as well as S. Chakravarti, and standing counsel.
I'm not standing counsel, I'm counsel representing ONGC.
And counsel.
ONGC doesn't have a standing counsel, they engage us. I'm in the panel.
Respondents. Part in part, this for further hearing on 15th is okay?
16, my lord, if possible, my lord.
No,
I have
15,
some-
my lord.
Some difficulties,
My lord, 15, 16 is
16,
a here, is a motion day, my lord, let it be on 15.
My lord, 16.
Or
My lord.
13th?
13th, my lord.
13, my lord, senior. My lord, 15 only. 15, my lord. 15.
That they, I think most of the hearing is over.
My lord,
except
so far
that
we are concerned, hearing is
in,
already
in the meantime,
My
you
lord.
can go through the affidavit that you have filed
in the
in this 5870
man.
because he has raised certain issues. Or would you like an order from this court to give you a photocopy?
That will also, it will be better, man.
Okay. In the meantime, comma, registry is also directed to furnish a photocopy of the affidavit in opposition. How many affidavits?
My lord, there are, my lord, three affidavit, three in my lord. I also filed, my lord.
I would say, my lord,
No, which one is the appropriate?
maybe he's referring to the affidavit filed by ONGC.
ONGC, my lord, 11/10/2023.
Respondent number two, man.
Respondent
Affidavit,
2, 3, ONGC.
affidavit of respondent number 2 and 3.
The affidavit in opposition filed by the respondent number 2 to 3
ONGC.
in public ONGC in WBC number 5870 oblique 2023. What order? What did they pass in the meantime? To Mr. S. Chakravarti, General Counsel for the respondents in the present petition. You can have a look.
Oblige.